May have the losses very kindly to mention one matter not in your lawsuit. But this is in criminal appeal of 1991. Yes. Now for the last 6 years, I am searching for the appeal. Have a look at the last order. That is a tax order. Last order. But this came up for hearing my Lord Justice Bharat. For the last 6 years, my Lord, I have written several letters to various departments. Only kindly call for the head of the Department of Criminal Appeal Section so that he can explain to your lordships why I am suffering for the last 7 years. The file is not traceable. No. For the last 6 years, my learned junior is haunting here and here. We have approached everybody, Registrar General, Registrar Administration. I kindly call for the head of the Department of Criminal Appeal Section. Let it appear as to be mentioned without the file, so that he can come and explain to your lordships while the file is missing for the last 7 years. লিস্ট নামেন যদি না আসে, ট্রায়াল ট্রেসেবল না হয়, লিখে দিয়েছি ক্রিমিনাল অ্যাপিলের যে বড়বাবু আছেন, আপনাদের হেড বা সুপারিনটেন্ডেন্ট হোয়াট এভার মেবি, তাকে আমার সঙ্গে দেখা করতে হবে। লেট মি সি, লেট মি ট্রাই। One judicial application. Give me a second. Yes, sir. Of which year, sir? Sub notice. And over this. Yes, sir. One revisional application, my lord, of 2013. May kindly be listed for here. Revisional application? Revisional application. I don't have any determination. My lord, revisional application. I have determination read and criminal appeal up to 2018 and original side execution and commercial side execution. Yes, sir. One appeal, criminal appeal is also. Which year, sir? 1987. Give this. My lord, I beg to mention service petition. But কি কোন ক্রিমিনাল অ্যাপিলে? ক্রিমিনাল অ্যাপিল সার্ভিসে কি দরকার আছে? তুমি রাখো, নিয়ে নাও। Yes, sir. Heard several times, my lord. By me? Not by. Then why are you saying? My lord, the thing is that, my lord, thereafter it could not be listed. My lord, I have tried my best, my lord, but it could not be. Perhaps it would be. So what do you want? My lord, I want inclusion in the list. I know the slave is within my determination. Notice, sir. দেখে নাও, নোটিশ থাকলে তবেই দেবে, নাহলে ফেরত দিয়ে দাও। টু নোটিশ আছে। I have served notice. One is hand over the slip, hand over the slip. Yes.
But in the year 2017, it was several times heard. All the parties were present.
Several times heard by Justice Partha Chaudhary then?
No.
Then why are you mentioning so?
No, my lord, as because
had it been a case that has been heard by Justice Sen,
not in the list,
not passed by the judgment by the Justice Sen, I could have understood.
Yes, my lord. It may kindly be taken, my lord, under the heading to be mentioned.
No. not under the to be mentioned. Had it been heard by me and not passed the judgment,
Right, my lord. The heart by the different.
then
Another thing.
it is not convincing for me. Hearing us.
My lord, may I submit only one thing, my lord, a date may kindly fix, then I will indicate the opposite parties that on that day.
It will be taken as per list. Yes, sir, madam. Huh? Service accordingly? First serve, then come.
Serve upon all the parties, my lord. Previously, my lord, it was served.
No, you have to mention prior to service.
My lord,
After service, then.
at the time of servicing, my lord, I will indicate the date.
Sorry, I maintain some discipline in my code. You have to.
I will make it a date, my lord. I will indicate a date that on that date.
I may be. I'm available in every day, except on the day where I'm sitting in division bench. Serve notice and then come.
I know.
Exchange of evidence are complete, I believe.
Yes.
Then the lawyers are available.
Yes.
Serve upon the learned advocates.
My lord, for inclusion hearing upon notice, my lord.
Read matters.
Yes, my lord.
Yes.
Great.
My lord, two assigned matters were there in the list of yesterday's cause list, my lord. They are not in today's cause list, my lord.
In appellate side matter.
My lord, appellate side matter.
দেখে নাও কিভাবে assigned matter বলছেন নেই।
Item number 17 and 18 of yesterday's cause list. My lord.
Wrongly.
My lord, should I hand over the mentioning clip, my lord?
ওটা কি লাগবে? স্লিপ লাগবে তোমাদের?
Grateful, my lord.
If it is not reflected in the tomorrow's list, please mention again.
Grateful, my lord.
কোড নাম্বার 3 তে মেনশন করা হয়েছিল।
এই উকিল বাবু আছেন?
মা আছেন, আমি
উকিল বাবু আছেন?
না।
ইন পার্সন মামলা করছেন? কি মামলা?
বাবু পড়েছিলেন সমস্ত কিছু, অ্যাপিয়ার হন।
উকিল বাবুকে বলেছেন যে আর আপনাকে অ্যাপিয়ার করতে হবে না?
আমি নিয়ে নিয়েছি।
এনওসি নিয়ে নিয়েছেন? এনওসিটা হাতের কাছে আছে? তাহলে মেনশনই নেব না।
করাই আছে।
মেনশনই নেব না। উকিল বাবুর কাছে আগে নিয়ে আসুন এনওসি, দেখবো তারপরে দেওয়া করবো।
Lord, may I be permitted to mention one original side matter, my lord, one exhibit.
Original side matter not now. Mention at on Monday. No. আজকে আছে না message?
My lord, today.
2 p.m. Come back at 2 p.m. Yes.
Lordship, I may kindly be mentioned to in person. Lordship, my matter.
You have a lawyer?
No, I have earlier since 99. I am appearing in person. Last mandatory order was passed by the Honorable Apex Court.
Prior
in
to that,
2000
prior to that, you have a lawyer.
No, I am in person.
All along you are doing
All,
cases in one person.
all in cases.
What do you want?
My lord, my matter is of 2001. Mandatory direction was passed by the Supreme Court in September 2003. In spite of that, they are not complying the matter. My lord, the matter was related to mines and industry. First order was issued on in the.
So what do you want for inclusion?
My lord, I want enlisting and upgradation, lordship.
Upgradation not possible. Hand over the
Lordship.
service serve notice.
Yes, obviously, lordship. Obviously, this is the service notice.
Service করেছে কিনা মেসেজ
Service notice. And this is.
সার্ভিস হয়েছে?
হ্যাঁ, ওই নিচে সার্ভিস হয়েছে। সার্ভিস করেছি লর্ডশিপ। এটা লর্ডশিপ, thousands of employees are depending on the mines and industry.
হ্যাঁ? 2025, I don't have any determination.
No, lordship, that matter is assigned by realizing of court number
Assigned to
2.
whom? Which court?
Court number two is release the matter. Justice.
It is a WP of 2025.
Yes.
This court has no determination.
No determination, but my lord, that matter is assigned before your lordship yesterday. That matter was heard.
It was assigned.
Yes.
It was notified in the website.
Yes, obviously, lordship.
Then why are you mentioning? It will be automatically listed.
Automatically, my lord, I am suffering since
No.
20 years.
Return the file. First, we have to ascertain whether it has been assigned or not. If it is not automatically, if it is assigned, it will be automatically listed. And if it is not automatically listed, then mention. Yes. Which year, sir? Call the list.
Lordship, just one.
My lord,
I am residing in Purulia.
Sir,
Lordship,
try
I-
to visualize my predicament. As on this day, right now, I do not know whether this matter has been assigned to me because I have been assigned up to 2018. If it is assigned, it will be automatically listed.
Okay,
Not
sir,
with-
Lordship, if you assign the matter, then may kindly be considered.
I request you take back this. It will be automatically assigned. If it is not assigned, you mention again. Yes. এই শোনা যাচ্ছে না।
may I be permitted to mention one original side matter? I have been served a
2
notice.
p.m. 2 p.m. 2 p.m. 2
Lord.
p.m. at 2 p.m. 2 p.m. Today 2 p.m. Yes, call the list.
My lord, I am for the petitioner led by Advocate Bikash Goswami.
You will do the case.
Yes, my lord.
Exchange of evidence are complete.
Well, on the last occasion, your lordship directed to file a report, my lord. Both filed a report, but state prayed for extension of time to file a report, your lordship. I don't know whether.
No,
Yes, your lordship.
দেখছি না তো।
No, but who is for the state?
My lord, I am appearing for the state, my lord. I am led by Mr. Learned AGP, my lord, Shopan Banerjee, my lord. My lord, instruction has been sought for, my lord, but till now, my lord, the instruction has not came, my lord. So, lordship, if your lordship kindly give us 1 or 2 day time, my lord, as soon as the instruction will come, my lord, we'll file the report, my lord.
The court will wait for the instruction of the
My lord,
state.
my lord, we have already intimated them, my lord, but due to some my lord, there is some problem, my lord. That's why they could not send the instruction, my lord. My lord, as the incumbent was there, my lord, he is not in the, my lord.
Take down. On behalf of the respondent state, an accommodation has been sought for on the ground. Who's for the petitioner?
The petitioner,
You are there for the lead petitioner.
no, my lord, I am for the state, my lord.
Then they will start, no? Mr. Mukherjee appear on behalf of the petition.
My lord, actually, what's happening?
Give me a second. You are Mr. Hawk.
Yes, my lord. I am led by Mr. Mahaprabhu. Last occasion, your lordship directed me to file report. This is the report, my lord. I have served the copy of the report to the petitioner also, my lord. My lord, petitioner claim.
Mr. Where is Mr. Mukherjee? Mr. Mukherjee appear all along.
Yes, my lord. Petitioner claim compassionate appointment on the
Click on.
death of his father.
The report has submitted on behalf of the
My lord, this
state.
certificate.
Who is your other sir, sir?
Mr. Indrajit Dasgupta as well as Mr. Devashish Chattopadhyay.
Where are they? Have you intimated?
Yes, my lord, the matter was fixed, my lord, in their presence, my lord. The matter was
No, sir. On 7th August 2024, this court passed an order requesting you to communicate the.
yes, it was done.
That
And
has been
subsequently-
done.
Yes. In the letter of intimation, my lord, handed over on the earlier occasion. And not only that, my lord, the last occasion matter appeared. My lord,
No,
matter
no,
was fixed today, my lord, in their presence, my lord. Mr. Dasgupta.
Mr. Devashish Chattopadhyay.
Yes. And not only that, Mr. Dasgupta also appeared, Indrajit Dasgupta. For some of the respondents, most probably, my lord, respondent number 4 and 5, my lord, Mr. Dasgupta is appearing. Huh? Right?
No, sir. Their name is not reflecting, sir.
My lord, so far as, my lord,
What the answering respondent?
answering respondent is respondent number 4, 5, 3, 4, 5.
3, 4, 5.
3, 4, 5, 6. My lord, your lordship, my lord, appointed Mr. Chattopadhyay, my lord, in this case, and subsequently Mr. Dasgupta, my lord, appeared and said, my lord, he had the instructions to appear on behalf of the, my lord, RPFC. My lord, Mr. Dasgupta is appearing for railway protection force, my lord, RPF.
Sir, kindly peruse the order dated 7th August 2024
But subsequently,
and subsequent orders. Has
But-
it been communicated?
yes, my lord, they appeared, my lord.
এই উকিলকে দাও উনি বুঝতে পারছেন না
Who's the-
Sir, kindly see the last paragraph of 7th August.
Subsequently, my lord, on
Kindly see, sir. Mr. Tiwari, kindly see. 7th August. 7th August. Have you communicated that order?
yes.
And after that, they appeared.
After that, my lord, your lordship, my lord, can you see, my lord, 20th September order, and thereafter, my lord, 29th order.
So,
20th
their presence is required. No,
Twen-
what do I do then?
I'll give notice.
That is better.
My lord, kindly make it not today, my lord, to let us come tomorrow. Or if we say that, my lord, I will give notice and or kindly make it not today, my lord, I'll give notice, my lord, let it appear on tomorrow.
Though the writ petition is represented today, none appears on behalf of the respondents.
Your Lordship,
It is
I am-
that matter, my lord,
I am
where
on-
without,
I am appealing for the
without
consent
complying the
order.
order, they have filed an appeal, then withdrawn the appeal, then filed the
Your
revision
Lordship,
application,
they
because
have
also let me
No,
complete.
let me
Let,
complete. I
this is
am
my
content, sir.
petition, it is
I
my
am
petition.
content, sir.
So at the
Yeah,
last occasion, your lordship,
Wait. Mr. Dhoni has a right of audience first. It is that matter.
that matter, your lordship desire was that
Mr.
before,
Bandyopadhyay,
yes, yes, before hearing the review application, they must deposit the, whether they will deposit before the register, and they have given me the calculation, we have checked up the calculation is correct.
Very good. And when the review petition is fixed,
It is listed in the
Your Lordship, my
fifth.
indulgence, one indulgence, Your Lordship. If the review and the content will give, the review is item 15 or 6. Item.
15, item 15.
Item 15. Your Lordship,
50.
No, one.
So, Your Lordship, the contempt and review are given. Yes, sir, Your Lordship will hear the contempt first. I am not on the way. But keeping it together will make it a bit logistical.
Your lordship's desire was that before hearing the review petition, it was also accompanied by section 5 delay. So
Yes,
whether
they
they
were
would,
supposed
they would
to file
secure
the
the amount,
opposition.
they would secure the amount, their contention is if the money is paid to us, then there will be
Your Lordship,
difficulty in,
kindly see the
in
order
case
of-
they succeed.
So
that's why your lordship
I'm
desire
taking
was-
the item number 15 because both of you are here present here right now. I'm taking the review petition. I'm passing an order for direct
Yes.
deposit of that amount.
Absolutely.
Your Lordship, with that regard, Your Lordship, Mr. Bandyopadhyay submitted petition that he would need instructions on that. Mr. Bandyopadhyay is not present today. As Your Lordship remembers, he opined that he would not be there.
Calculation
All right.
He is not here. Kindly do not record that order to me and let Mr. Bandyopadhyay come back with the instructions on that. With that regard, just one.
That instruction already taken
Very
and
good. এই
calculation
বললেন,
submitted.
একটা কাজ করুন। All right, I'm passing an order. On behalf of,
Annex containment number 2, finance department.
very good. On behalf of এটা হয়ে গেল 15টা হয়ে গেল বুঝলি? এটা কত ছিল 5? ও 4টা হয়ে গেল আর 15টা হয়ে গেল।
This is my application. The appeal is pending in court number 11. Court number 11 is not sitting till 27th of this month.
হ্যাঁ
So, my lord, kindly adjourn this matter in March.
আসুন, on behalf of the on behalf of the petitioner, an accommodation has been paid for since an appeal has been preferred by the respondent authorities challenging the judgment dated 8/2/2024. Mr. Lairi, judgment dated 8/2/2024 as passed in WPA 17915 of 2007 by this court. Am I correct, Mr. Lairi? Stop. In view of such, let the matter be listed in the monthly list of 2025. Now, a monthly list of April 2025 under the same head. April. In the meantime, we'll get the appeal heard.
But I am for the petitioner. Pursuant to your lordship's direction, my lord, further notice was given. My lord,
I am appearing for the contract.
what happened, my lord? I'm just taking
With
your
the
lordship
report.
5 minutes time, my lord.
Yes.
My lord, the petitioner before your lordship, my lord, is a senior citizen in Harping. We were pillar to post, my lord, for demolition of an unauthorized construction. Now, my lord, kindly see once, my lord, the report which was filed before your lordship by the Howrah Municipal Corporation. My lord, kindly see once the report which was, my lord, affirmed by one Biplab Rai.
In the contempt report, in the contempt
In the
application.
I'm coming. Kindly see the petition, the report which was filed, that is with your lordship's file. The report is affirmed on, my lord. If your lordship see
Let
once,
me see my order first.
yes,
Mr. Mukherjee. The order has been annexed with the contempt application.
absolutely, my lord. Order at page 22.
Page 23.
22.
22. Where is the operative portion?
Operating portion, your lordship will find, my lord, page 4.
Internal page.
Page 23, paragraph 4.
Give me a second. এই খুললেন হাওড়া মিউনিসিপাল কর্পোরেশন একটা বার করুন। হাওড়া মিউনিসিপাল কর্পোরেশন
I have.
স্যার I have booked, sir.
7 এর আছে।
Yes, Mr. Mukherjee, দাও।
Now, my lord, kind.
এটা দাও বাবা।
Oh, that is affidavit of service. My lord,
Now kindly,
I'm appearing.
Yes, yes.
now my lord, kindly see the report which was filed before your lordship's court, my lord, which was affirmed on 4th October 2024. My lord, it is necessary because on the basis of the report, your lordship passed the order. Why I'm showing to your lordship, my lord? But what is the matter before your lordship, my lord? That a person made some unauthorized construction without legal report.
Report which portion?
Yes, my report, my lord, I will show, my lord, from page 5. My lord, before filing of the writ petition on 15th March, at the bottom left-hand side, your lordship will find 15th March 22, a notice under section 177(1) has been issued against the, my lord, the offender, that is person responsible. Now kindly see page 6, next page. Thereafter, a so-called notice was also issued.
It has been taken care of.
Required, my lord. Kindly, I know, my lord, I'm wasting your lordship time. Kindly see, it is required. So-called notice was issued. The vital page is page 7, my lord. Kindly see once. A hearing was given, and my lord, kindly, approx unauthorized area is 300 square feet at each floor up to G+3 level unauthorized area. But have your lordship got it? Then last line, he admits his fault and begs for excuse. Therefore, the person responsible admitted his fault. Therefore, there is no dispute regarding the area of unauthorized construction in each floor. Now, my lord, kindly see the next page. Since 18th May 2022, my lord, next reminder 30th June 2022, then 25th May 2023, then 12th July 2023, then 14th September 2023, then 8/1 2024. 5 notice has been issued for demolition. They did not done so. That's why, my lord, they invoke the provisions of 177 subsection 7. What is 177 subsection 7? That if the person responsible did not demolish the portion, the corporation will demolish and recover the cost. Now,
Definitely.
now thereafter, what happened, my lord? Your lordship will find at page 14 of the report, they wrote a letter to the page 14 of that report. The officer on special duty wrote to the additional deputy commissioner of police, SB, special branch, but for providing police assistance, and that is at page 14 of the report, my lord. Annexure R5. But on the basis of this averment, your lordship passed the order. Now, after passing of a lordship order, one day, my lord, the corporation authority and some few police personnel came. Only 3 holes has been done. Let anyone go and found and make an inspection whether, but in terms of the corporation order, that whether 300
That demolition has been taken place.
Absolutely. This is fine.
Order is, I am placing the order first. The portion of the order, the court, my lord, page 23, my lord. Para 4. The court finds no force in the argument of so and so, primarily as it appears so and so. The assistant engineer of building and he was given due hearing so and so. This court also finds by letter the private respondent was asked to demolish the authorized contract. That is there. Numerous times they were given reminders. But thereafter, Mara directed the additional Howrah is directed to deploy sufficient number of so and so under section 225. Howrah Municipal Corporation is requested to take steps for demolition. Under section 177(7). 77(7) is there. May I read, my lord, for your lordship? Because we,
you have to carry out the entire demolition.
I have that I am telling, my lord. I have come with the report also. We are very much scared of your lordship's order. How can we know? And now, secondly, my lord,
then I shall appoint a special officer.
Yes,
We will
that
go.
I am saying, man.
We will go and visualize and submit a report.
And my lord, what is the demolition construction is this? G+3 sanction plan within, but deviation is there in the G+3 building. 4 is the extra floor that has been demolished. And my lord, I am placing this one. I am placing the report.
May I get a copy, my lord?
Yes, I will.
But my
now, if the petitioners will now dictate us how to demolish, where to demolish.
This is not my at all case. I say only to comply.
যখন আপনি বলেছেন আমি বলিনি কি আমাকে একটু বলতে দিন, আমাকে তো আমার নাহলে আপনি বলুন
স্যার
আমি শেষ
আপনি
করবো।
কার হয়ে অ্যাপিয়ার করছেন তো বুঝতে পারছি
আমি
না।
তো কর্পোরেশন হয়ে অ্যাপিয়ার করবো, আমাকে তো কর্পোরেশন থেকে দিবেন, আপনি তো কর্পোরেশন নামে বলছেন 4টে হোল করেছে,
হ্যাঁ আচ্ছা আচ্ছা। না
তাহলে আমি কার নামে বলবো?
প্রাইভেট রেসপন্ডেন্ট কিছু করেনি তো
না,
তাই
প্রাইভেট রেসপন্ডেন্টের সঙ্গে আমার কোনো সম্পর্ক নেই, কারণ কর্পোরেশনকে আপনি বলছেন 4টে হল, আমি প্রাইভেট রেসপন্ডেন্ট নামে বলুন, তাহলে আমি কিছু বলবো না।
Sir, make submission to the court.
They are saying that
Mr. Mukherjee, please be
I'm sorry.
quiet. Yes, sir.
the report says para 3 stop work notice issued on 15/3/2022, so-called notice that has been done. My lord also knows. Self demolition notice has been numerous has been issued, and they have said 1 day demolition has been done. Demolition was done dated 13, that is clause 7. Demolition was done as dated 13/11/2024 and 21/2025 with the help of police. About all unauthorized construction at 4th floor was demolished. Also, parapet wall over deviated portion was demolished, for which a letter for demolition cost is issued upon the party. Further demolition of deviated portion may cause affected sanctioned portion. Now they have to give the undertaking that if it is affected, we will go for demolition. Affected with the sanctioned portion. Also, the building is fully occupied now. Maybe.
Absolutely not. It is a hotel.
Maybe.
It is a hotel.
Maybe, but sanction plan may be affected. Sanction portion. Demolition cost notice issued on 5.
No, read clause number 8 and 9 once again.
My lord, about all unauthorized portion at 4th floor was demolished. 4th floor is completely unauthorized. My lord, also parapet wall over deviated portion was demolished, for which a letter for demolition cost is issued upon party. Further demolition of deviated portion may cause affected sanctioned portion. Also, the building is fully occupied now.
So,
Because the building is
it
fully
shows
occupied.
that you are non-compliance.
Man, I'm just trying to convince your lordship. The G+3 building, it is an occupied portion. Maybe it should be, because it is a planned building within the sanction plan. And so far as the deviated portion, that can be demolished when the occupiers are there inside. That can, because we will not demolish the entire G+3 because it is the G+3 sanctioned building. What they are wanting that we should demolish in any manner whatsoever after vacating the
No, no,
entire.
yes, evacuate the occupier of the unauthorized authorized construction, carry out the unauthorized construction, then put them in. What is the
It is
difficulty?
a hotel. No question of arises, my lord, but occupation.
I
I am residing there. I know.
Mr. Mukherjee, please be calm.
Let me-
Come to page number 7 of your report, earlier report.
Well, if your lordship so says, I will again go. No problem. Even I will.
No, I have said already. You have to carry out the order or to file an appeal.
At our satisfaction, my lord has said.
No, your satisfaction is not
Only satisfaction.
satisfaction of the court is required.
Of the court, provided that the authorized portion may not be demolished, because they want the authorized portion may be demolished because
Absolutely not.
they are.
No. In the event they have done the mischief for carrying out the demolition in the unauthorized portion, if the authorized portion is going to be affected, let it be affected because it is on their fault. They will do.
Pass that. Because we are thinking about that, they will again file a case for pecuniary damages. Our authorized portions have been affected. This is our problem. We are in problem from both of the sides.
May I reply just
No,
one?
I am not completed.
No.
If your lordship so desires, my lord may give me at least a month's time. I will come with the entire 4th floor demolition has been done. With now, I will get the occupants vacated from the house entirely, and thereafter I will cause the demolition. My lord may just observe in the order that it.
Mr. Banerjee,
My
please
lord.
come to page number 7 of your earlier report.
Page number 7.
Mr. Mukherjee, if you have copy, please give it to me.
My lord.
Come to the middle portion. Approximately unauthorized area is 300 square feet approx at each floor up to G+3 level unauthorized area.
Yes.
So this has got to be demolished.
Now I will come with the extent of demolition done, if your lordship so desires, and thereafter I will also demolish the entire. If it causes affected the authorized portion also, that I will also do. My lord may give an order that a report has been filed it will, so far as our observation is this, it may affect it further.
You said 300 square feet approx at each floor,
Yes,
up to G+3.
because we
There
are,
is up to fourth floor. There is from ground floor to fourth floor, there are another construction.
fourth floor is the entire. Only G
I
plus,
don't know, your report
G
says.
plus 4, G plus 3 means 4 floors. Thereafter, there is another floor. G plus 3 means G, 1, 2, 3. There are 4 floors.
Total 4.
Total, above that, that was another floor, man. That has already been demolished. And deviated portions is G plus 3. That means 4 floors are deviated portions there.
Sir, now it is, you cannot say it is deviation. It is an unauthorized.
Unauthorized. Deviation is also unauthorized.
Then,
if your lordship so directs, I will come with a report, compliance report within 1 month regarding that, showing that how much deviated portions we have demolished, and if it requires, we will also demolish the further portion also. But it may touch the authorized portion, it may touch.
One in reply, my lord.
The G plus 3 building, it is a big building, and now buildings are collapsing like that.
take down.
In reply,
Madam.
kindly hear me 1 second, my lord, 1 second.
Only
But-
1 month time, maybe.
But the private respondent who admit before the authority, they appeared before your lordship. They did not challenge your lordship's order.
Yes.
Now, my lord, it is an hotel. Now, no question arises, my lord, for my lord, entire occupation, my lord. It is not a house. It is a hotel. And my lord, kindly appoint any my lord, engineer or my lord, from the list of the panel of your lordship's court. But he will find 4th floor not touched, and each floor, my understanding is saying they have demolished. Now they have not touched anything. They have only give some hole. And another thing, my lord, why the corporation is not worried that it will affect the sanction portion, and the person is kindly see clause 9. Further demolition of deviated portion may cause affected sanction portion, and also building is fully occupied. Kindly mark this. This is a false affidavit because it is a hotel. This cannot be a my lord, this cannot be a
My lord,
building.
let
This is a hotel.
Let that be
Kindly-
said, the corporation
Why, my lord? Already
observation
order this there.
is completely false. Let the unauthorized portion be demolished. If any uneven things happen, then they will be responsible. We will do it.
For whom he is
Take down.
applicable?
Yes, at least I have heard.
We will do it
Let-
because your lordship directed me in terms of
Both the
the
petitioner
127. My lord has asked me to
And
demolish. We have done it.
and the alleged contemner numbers 1 and 2 are represented by their respective councils. Stop. The affidavit of service as filed today on behalf of the writ petition is taken on record. A photocopy of the report dated 10/2/2025 as submitted by AE within bracket Building Department, Howrah Municipal Corporation through Mr. Banerjee, learned advocate for the alleged contemners, is also taken on record. Stop there. At the time of hearing, Mr. Mukherjee, learned advocate appearing on behalf of the petitioner, at the very outset draws attention of this court to the order to the the order dated 4/10 to the judgment dated 4/10/2024 as passed in WPA 18810 of 2024. Attention of this court is drawn to paragraph 5 of the said judgment, which runs as under. এটাকে set out করবে। It is submitted by Mr. Mukherjee that
I appear for the applicant. AVT
I am appearing on behalf of the contemplated bank, your lordship, in this matter.
My lordship will find your lordship's order at page 15 of the application.
Let the file be placed first.
Page 15 of the application.
Central Bank of India.
Lordship.
Page, sir. Mr. Majumdar,
Page 15 is the order. The order
operative
starts,
portion.
the operative portion lordship will find at page 27, paragraph 27 and 28. The direction passed by this honorable court.
Reduction of basic pay by 1 state in the So they are to carry out the paragraph number 28.
28.
What they have done?
Now, what they have done is in the 2023, they preferred an appeal. They did not take any step to list the appeal or hearing of the appeal. It is only after this contempt application was served on them in the month of January 2025 that they mentioned that appeal. Now, there is no stay, nothing. So, I would kindly request your lordship to issue a rule and let them answer the rule. Then why they have not complied and why they have been sitting tight over this judgment for the last 1.5 years.
Have you calculated, sir?
Nothing.
Lordship, appeal is pending before the bench, your lordship. Lordship, I have mentioned before the bench, but due to demerit, your lordship, that the lordship is sitting. No, at least you could have made the calculation. Has not been listed and heard, your lordship. Then, sir, I am issuing the rule.
Let them answer the rule.
Lordship, thereafter, I have mentioned before the honorable chief bench, and lordship has. No, very good. You have, at least you you do some positive words. So some positive words. Lordship, allow me. Why is the difficulty in calculating the residual dues? Lordship, at least allow me some time to carry out my appeal, and thereafter.
The appeal was filed in the year 2023. They did not take any step till 2025.
You will get within 7 days. You have to calculate that the return dues and submit it to the court. Failing which, I shall issue the rule. I am not asking for immediate disbursement of the amount. You have to calculate at least. Ashwin.
Grateful.
One thing, the affidavit of service as filed today is taken on record. Lordship, one thing, my contention, that contempt has been filed after 1 year. Kindly. Sir, is there any limitation for filing any contempt application?
Yeah. It's a continuing cause of action, your lordship.
Application is 1 year.
The cause of action arises every day. It's a continuing cause of action.
Nothing. Not any act provides.
Non-payment of benefit, non-payment of retirement benefit is a benefit.
The affidavit of service as filed today is taken on record. And advocate for the petitioner at the very outset draws attention of this court to paragraph number Call the next matter.
Already in item number 8, I am appearing on behalf of petitioner, your lordship. Yeah, I the respondent. But on the last occasion, there was a direction for filing sub.
Is it item number 8? The content?
Actually, content is there, but lordship is hearing the main writ application.
Why it is listed under the heading application? Any
Because my lord,
can is there?
substitution application is.
Oh, I see.
I have filed one application for substitution of
Say
the
like
respondent
that.
number 13, your lordship. Lordship, since my lord is reading my lord's last order, my lord will also see paragraph number 3 of my lord's. Yes, your lord. There was a direction for filing affidavit in opposition that is also ready. No, reply. Reply has been filed by us. My mistake. Affidavit in reply.
ক্যানটা বার করে দেবেন তো নাকি মোটাটা তুলে দিলেই হয়ে গেল
Can 4 of 2025.
বার করুন
দিন দেবে না কাজের হয়ে আছে কোন কোন
গৌরব
সবগুলো তুমি for the time being, may I give my copies so that the matter it has
No,
been
no.
solved by the.
it has to be searched out. Wait for a second. পাওয়া গেছে It is reported by SEO. Again, it is reported by SEO that can pour up to
It is ready, but it is not affirmed. So I am updating the time can be extended till 17th.
the affidavit in
And I
reply.
will serve a copy.
The
before
affidavit in reply as directed to be filed on 13/1/2025 is parentality to be filed on the adjourned date. Call the next matter.
It art.
Review.
Review, my lord.
Review in civil revision.
My lord. My lord, I am led by Mr. Kollol Batu, my lord. And he fixed a time for
Fixing a time, it has been fixed. Who's the other side?
review, my lord. It is at
Execute a query. এটা নাকি? The order was passed on 17th April 2023.
23.
So it is within time.
No, my lord. There are 4 applications in the connecting with this review. One is leave to file appeal by one of the petitioner. Because
Service has been affected.
no, my lord, at this review, my lord, unless and until it is admitted, how can I?
Section 5 is there.
Section 5 is there, my lord.
They have to serve notice.
My lord.
Which one is section 5?
Section 5 is, my lord, can 4, my lord.
How many days delay?
5,
79 days.
579 days, my lord.
আসুন। On perusal of the entire matter as placed before this court,
Municipality का service को document. मतलब maintain status को in that meantime. Lordship.
My lord, item number 11, 12, 13, 14, all are similar matters. And there was an earlier direction by your lordships that this should be taken up together. Lordship stayed the impugned notice and directed to file an affidavit in opposition by the Madrasa Commission. My lord, today, just now, the affidavit has been affirmed. Now it is yet to be served. May I pray this so that
what is the predicament in affirming the earlier date? What is this?
should have been, but only thing is that my lord, there are another bunch of matters within identical points where before the honorable
But I am appearing on behalf of the petitioner, my lord. Pardon me. I am appearing on behalf of the petitioner in item number 13, my lord. Pardon me, my lord. Due to my medical condition, I am unable to go there, my lord.
No, no issue.
Gopal,
11 and 12 have been tagged together.
Well, there are earlier orders also. Lordship may kindly see that order dated 17th of January 25.
Para 6.
Yes, paragraph 6.
কোনটা বলছি? WPA 11 and 12 have been tagged together.
13 and 14 also tagged together, my lord. Kindly see the 17th January 2025 order passed in, my lord, 2609 090 of 2025.
That is 14. Item 14. Order dated.
Identical matter, two identical matter, my lord. That is tagged together, my lord, and my lord passed this order on 17 January, my lord.
Paragraph 6 of the order.
Review application. Review application back লিখে রাখুন সিভিল ডিভিশন মানে এই ছোড়া ওই আন্ডার দি হেডিং ওই রিভিউ পিটিশন কি বলেছি না রিভিউ পিটিশন উইদিন ব্র্যাকেট সিভিল ডিভিশন দেখি কি অর্ডার বলছেন দেখান তো
Lordship, kindly take item number 14. 13 or 14, both.
Paragraph number?
Paragraph 6. Order dated 17th of January.
It was directed to be listed along with such and such,
Yes,
not tagged together. There was no tagging order.
correct, correct.
There is a tracking.
Earlier, there was a coordinate bench order. Gopa handed over the earlier coordinate bench order. There are 4 matters mentioned in earlier coordinate bench order, my lord.
My lord, in any case,
Order
these are-
dated?
My lord, 29th October 2024. My lord, will find item number 13.
In item number 13, my lord, there is a specific order in coordinate bench, my lord. I believe my junior will
Order
hand it
dated?
over, my
Order
lord.
dated?
Order dated 29 October 2024.
বললেন এসব
The last
এক করবে
paragraph.
জানো অর্ডার বুক আলাদা করো নাহলে অসুবিধা হচ্ছে 29
October 2024. My lord, order dated.
Handed over the order.
My lord, may I hand over? So it is marked.
যাতা কাণ্ড in WPA
My lord, 2623.
6090.
My lord, may I hand over the order, my lord, for your my
please give it
lord,
give
though, my lord, it is marked, my lord.
no it's all
Madam.
কি করছি অর্ডারটা দিয়ে কি করছি না ট্যাগিং অর্ডারের কথা বলছেন
একসঙ্গে আছে, ওটাই আছে। ওটার মধ্যেই 4টে আছে।
26237 ও এইটাতে অর্ডারটা আছে Yes, there's an order for tagging.
Yes, my lord.
Very good.
My lord, may I say only one
My
thing?
lord, kindly see the second page by mentioning the case number, my lord.
My lord, in fact, the opposition
Yes.
filed by the Madrasa Commission in item number 13, my lord, that can be used for the other matters also. There are 2 oppositions which have been affirmed today itself. Here and now, my lord, I am serving to my learned advocate. Now,
Item number 13.
13. Because, my lord,
It's
one
my matter, my
may be
lord.
taken up subject to, my lord, consent of my learned friends. One matter may be taken up as a lead matter because the point of law, whatever we
Yes,
have
yes.
in one matter, that will follow to other matters.
And my lord, I want to file reply in this regard, my lord.
Not
Kindly
all.
keep.
Give me a second, sir. Please, he's a
Sorry,
your friend is
I'm
making
extremely
a
sorry.
submission.
There is some bunch of matters before your lordships.
4 matters.
Yes, there are 4 matters.
And there is an order for tagging
There is
Yes.
an order of fact
because of the identical
Correct,
nature of the cases.
now today what I am praying is let one matter be taken up by an order of your lordships as a lead matter. Now, if they propose for any particular matter, I have no difficulty. I propose it may be item 13 so that it would be convenient for all of us to refer respective pages at the time of hearing. I also have one small submissions. The other bunch of matters on identical point were also before the Honorable Justice Amrita Sinha. Well, this matter relates to a recruitment process of madrasa starting from 2010. For a long period span over about 10 years, the law relating to madrasa commissions was declared to be ultra vires. So the recruitment process was started when we were intra vires. Calcutta High Court declared it to be ultra vires, initially single bench. The Honorable Division Bench affirmed plus declared even some other provisions to be ultra vires. Went before the Honorable Supreme Court. There was a stay. Ultimately, the Honorable Supreme Court set aside the single bench and the division bench of the Calcutta High Court. After setting aside, now we have whatever we started. So that is the resurrections and completions. So it has, in fact, I have been roped in also very latest. It has a, I would say, the complexity of facts and other things in this matter. And as a counsels, I have felt that there are 2 sides of the matter, and there is a possibility that one view is a more appropriate, one would be less appropriate. Appearing for the commission, my lord, I would try to be as neutral as possible, and I would place all the cards because contention of the petitioner should be that no, there should be less number of candidates who should be in the zone of considerations. The action of the commission was that we made a mistake for which 73,000 would be affected. Now, if your lordship feels no, that no, they remain affected, we may not include them. In any case, entirety has been stopped because of your lordship's interim order. All I am praying that would your lordships kindly keep the matter on a particular date, and in the meantime, so that my learned friend can use the affidavit in reply.
So you intend to file affidavit in opposition in item number 30?
I have filed the affidavit.
Yes,
in
no, I want to
It
file
has been
it.
taken on record.
Today, lordship,
Reply
You
in
are
this
going to
regard.
file.
yes, and
It will
lordship,
be treated as an affidavit in opposition in respect of the
All
item
the
number
Kindly, my lord, extend the time to file the affidavit in reply.
10, 11 and
Well, I am, may I say this? Well, I am filing the affidavit in item 13 and 14. Now, separate.
Very good.
Basically, contentions are same. Now, the same may be taken to be my oppositions for the other matters also.
So, so far the affidavit in opposition in item number 13 or 14 are concerned,
Yes,
those are identical.
those are all matters are identical.
Then why have filed two separate affidavit of opposition?
But in item number 13, there is an additional point that is why.
Well,
On last occasion, they have mentioned.
what I understand is the fundamental point is identical. There may be some slightly cosmetic differences.
Very good. Take down. Which opposition?
In item number 12.
Item number 12, there are
আমাদের
very good. What are the cans for in item number 12?
Well, 12. Well, I have, because it's a fundamental point. So far as the addition part, there is an affidavit in opposition also.
এটা নিয়ে নাও যে at the time of hearing order for tagging was passed in item number 14 or 15? 13. At the time of hearing,
about 14 years. There was some opposition filed. I prayed that a comprehensive affidavit may be allowed to be filed by me, and that was allowed. And that was the order on 31st of January. Now, I am for the respondent. I don't have much role, but I would be requesting, because now for the identical issue, if two honorable courts, then there is every likelihood the fate of, my lord, the thousands of candidates they should not, because they already faced, my lord, lot of difficulties. So I just felt that the whole energy by both the sides should put in before one honorable court. And for that, if there is anything required to be done on our part, my lord, we are absolutely fine with that.
So what would be your submission? Identical matters are there. No, it's not
That was
assigned.
also no. This
It
was
is
also
assigned.
This is the difficult. It was assigned, and those were also assigned. It's not that otherwise would not have been any difficulty. Now we cannot take a partisan thing, because I have requested my learned friends that if you can talk to the petitioner's advocate.
So why are not approaching the Honorable the Chief Justice for
That I was thinking of. But approach
We have
can
to
be
write
done by the petitioner's advocate with consultation with
either by this bench or that bench?
Now, we are agreeable to that. Only little nudge of your lordships would be required, nothing else. So that the Honorable Chief Justice decide a particular bench, and that bench decides the matter in entirety.
My lord, I was appearing for the petitioner.
Mr. Dhar is submitting that some identical matters are pending before a coordinate bench. And that matter has been assigned to that bench, and this matter has been assigned to this bench.
My lord, these matters have been assigned to your lordship. My lord, your lordship may very kindly take it up, because your lordship has been pleased to pass previous orders in the matter.
No, those are interlocutory orders, Mr.
Very
Those
well.
are
Very well.
ultimately- Mr. Dhar is absolutely right. If two contrary orders are to be passed, that will be a mess.
But while saying so, I don't want to give an impression as if I want to run away from your lordships.
No, that I understood.
I just want to say that the candidates must know their fate with certainty. Even if something is, because it's a coordinate bench.
Milord, I shall personally try to have a word with Mr. Dhar. Lordship will kindly keep it tomorrow. We shall come back to your lordship, Milord, tomorrow, Milord, with the straight instructions as to what we propose to do. I shall take instructions from Mr. Dhar.
I have indicated my clients, so their answer would be yes, agreeable to whatever petitioner's advocates feels that. We are absolutely fine either with your lordships or
ultimately, since my learned senior Mr. Pratik Dhar is making this submission, Milord, I request my lord to kindly adjourn the matter till tomorrow, Milord. We shall come back to your lordship.
Only tomorrow I may have.
ওইটা তো হলো তো যেখানে আমি বললাম না let the matter be listed আছে ওইখানে ওইটা আগে একটা প্যারাগ্রাফ আছে at this juncture Mr. Dhar, learned senior counsel appearing on behalf of the Madrasa Service Commission and its functionaries has handed over a server copy of the order dated 31/1/2025 as passed in WPA 24588 of 2024 with WPA 29253 of 2024. It is submitted by Mr. Dhar that the 4 petitions which are pending before this court and the aforementioned 2 petitions which are pending before a coordinate bench are identical in nature. Stop. It is further submitted by Mr. Dhar that the said 2 petitions being WPA যেটা বললাম and WPA number such and such, ওই যে 24588 আর 29253 have been assigned to the coordinate bench. And the 4 writ petitions have been assigned to this bench. Mr. Dhol, under senior counsel, the submits that that in order to avoid chance of passing conflicting judgment, it would be appropriate that all the matters be placed before a particular bench. Such being the position, the bat is given to the parties to approach the Honorable Chief Justice.
We don't intend to, kindly keeps it tomorrow.
For assignment.
Kindly keeps it tomorrow,
If his lordship so chooses.
Kindly keep.
Let the matter be listed on that. Let the matter be listed. যেটা বলে দিয়েছি আগে বলেছি সেটাই থাকবে। তারপর একটা লিখে দেবে to date for awaiting appropriate order from the Secretariat of the Honorable Chief Justice.
This little nudge of your lordships would be helpful for all of us. Because
Today
while
for-
writing letter,
For awaiting order from the Secretariat of the Honorable Chief Justice.
because now it will not be an impression that any of
No,
the
no, I am not releasing this matter. I
I
am fixing
understand.
in this
I
matter.
clearly understand. Now, the Honorable Chief
একটা
Justice
কাজ
would,
করবে কি ওই ক্যানটাকে না ক্যানটাকে রেখে দেবে যে আমি ডেটটা ফিক্স করছি
there is a likelihood that because of this order, all matters might come before your lordship. Yes, whatever the Honorable Chief Justice feels.
My lord is kind enough to keep it, Milord.
I'm fixing. একটু দেখা যাও তো 25th ফেব্রুয়ারি কিছু আছে দুপুর 12টার সময় করলেন 25th ফেব্রুয়ারি 25th February 12 o'clock noon.
Yes.
Yes, your lord.
Milord, I am unable to hear your lordship, Milord. Your lordship, I shall ascertain from my instructing advocate, Milord. I shall ascertain from my instructing advocate.
25th February at 12 o'clock noon as a specially fixed matter.
12 o'clock.
I'm grateful to your lordship.
Deeply obliged. Order বলা আছে
আমাদের ঠিক আছে
Who's for the respondent, sir? Cost has been paid. Affidavit in reply. Give me a second, sir. Yes, make your submission. Yes. Hmm. Yes. What is the date, sir? Fourth April is the date when we went to collect the check. So the date, my lord, I was asked to collect it. When you have sold? Well, this was on 27th of March 27. Sold jute, no? Sold jute on 27th of March 27. 27/3/2007. To whom you have sold? To the respondent authorities. Who are the respondent authorities? Very good. The respondents, very good. To the respondent authorities. Very good. Then what happened, sir? No, my lord, on 4th April, I was asked to collect the check. 4th April. Yes. But I was asked to collect the check. Yes. I went there, but it was not. Back to that, my lord, I have not handed over to. Now, my lord, kindly have a look page 12 of Annex Chapter 1. Page 12 of my lord. Yes. My lord, I got it. My lord, this is the, my lord, kindly see the first column top, the Jute Corporation of India Limited. Second column, Pakistani from Remo Book. Then, my lord, the serial number. These are the, my lord, the two types of page 12 to up to page 15. Page 12 to 15 are? 15, my lord, the outer, which, my lord, they receive two copies. বললেন একটু এসিটা বন্ধ করতে বলবো, ঠান্ডা লাগছে। Yes, brother, I only wanted to. I am talking with Mr. Yes, yes. It's become cold. এসিটা বন্ধ করতে বলো খানিকক্ষণের জন্য, পরে আবার চালাতে। হ্যাঁ, ব্লোয়ারটা চলুক, নাহলে সাফোকেশন হবে। Yes. They have received this. This is the. What are the total quantity? Can you say? Past 12 is 26.88 kg. 13 is 27.70 kg. Where you are getting? Kindly have a look, page 12, right hand side. Bottom. 26.88, 27.70, and 15.10, and lastly on 27.15. Yes. What happened thereafter? Page? Next. Yes. This is kindly have a look at the state of State Bank of India. Just gone on State Bank of India by the Corporation of India. It does not contain the signature of junior accountant. So according to you, the check for the sum of rupees such and such was made ready, but there were joint signatories. So one of the signatories have signed, but the other signatories have not signed. But even then it was handed over to you. Then how you have got it? Opposition, my lord, the only point is taken. No, what is your prayer then? Prayer of the time taken. There can be a direction upon the DCI to pay my dues. Release this whole price of the jute. So what case has been made out by you for not handing over the check according to you? According to my lord, the opposition, not the opposition has been filed the only point. No, yeah, in your I'll come to your opposition. In your application, have you stated why the what plea has been taken by them for not issuing the check? Paragraph 4, my lord, at internal page 4 of. Yes. Your petitioner states that on 4th April 2017, going to put input correct the check that is the savings price of from the corporation, but from the office it was before the petitioner due to some technical fault that check was not prepared in favor of the petitioner. Next, your petitioner states that 6th April, as per advice of the official of the regional manager, he gave an application to the regional manager with a request to issue of the savings price of sold by him. Next, very vital, your petitioner states that on 8th April 2017, the regional manager for directed the petitioner to collect the check from the petitioner immediately asked the office of the manager for input, but he refused to hand over the check. But after receiving the phone call from the office of the regional manager, compared to hand over the check by endorsing his signature and seal upon the same check, but accountant refused to sign the same copy that the bank for himself. The petitioner states that he immediately filed so the check which has been signed by one of the signatories has been handed over. But it cannot be encashed. Because of the joint signatories. He has not refused to put his signature. Very good. What is their case then? Only case as my understanding, mother. Only case made out that these vouchers are not the selling voucher of the. Have they communicated the same earlier? No, nothing has been communicated. That is why my lord, I made representation several times. That was not idea to then I approached this. No, you made a representation on 26 May 2017. 26 May 2017. It was not replied to. No, that has not been my lord adhered to. Then my lord. No, it was replied to that it plea was taken that it was not the right. No, nothing has been. Very good. What is their opposition then? Another representation, July 27, page 20. Twice I requested. So according to them, those vouchers are the fake documents.
They have not said. That is the crux of the matter. They never say that cakes are forged or manufactured.
No, vouchers.
Voucher, they say this is not carrying with their purchase voucher.
Show me the relevant portion of the repeat opposition. Sir, may I know your good name, please? Yes. Show me the relevant portion, sir. This is denial.
Paragraph 13.
Prior to that, I want to place a very vital paragraph. Paragraph 10, internal code
Of
their
if you mention paragraph
10.
internal page
Internal code of the
para 10. Yes. Please.
With respect to the statements made in paragraph 5 and 6, I admit of nothing expecting what is borne out from the admitted record. I say that it is however the admitted fact that accountant refused to sign the check. It also needs to be pointed out that the manager has been suffered disciplinary proceedings, which culminated in his demotion by one scale for unauthorized putting his signature on the check.
Yes.
Therefore, it is crystallized that they have admitted that there was a mistake or anything from them, not from me. Am I responsible or am I answerable for any disciplinary proceeding? This is their employee.
No, sir. Question is with regard to your entitlement, whether you are at all entitled to that amount. That is also required to be looked into.
Now, kindly see paragraph 15. The opposition.
Yes.
The disciplinary proceedings were initiated against the managers who had signed the case posted. While imposing a penalty on the said employee of DCI, it was categorically observed that the case were issued based on the entries made diary instead of the purchase tally. It is submitted that the purchase tally is the official document to record the purchase of property. And it is reiterated that the purchase tally from memo book used during the period of purchase are of series 12 to 12 to
Sir, I'm sorry. Will you please once again place paragraph 15 entirety? Please.
that disciplinary proceedings were not only
I got it, sir.
that disciplinary proceedings were initiated against the managers who had signed the case in posted. While imposing a penalty on the said employee of DCI, it was categorically observed that the checks were issued based on the entry made value instead of the purchase tally. It is submitted that the purchase tally is the official document to record the purchase of raw goods, and it is indicated that the purchase tally, the memo used during the period of purchase are of series 12 to 12 to etc. Where the purchase memo relied upon by the petitioner belongs to an entirely different series, being 12 to 12. No official document available which record the purchase of raw goods from the petitioner against which the case has been wrongly issued. They now say wrongly issued by the hiring officer.
No, how they have dealt with those documents?
Only they said these documents, paragraph 12 to 15. My lord, paragraph 12 to 15 is not the purchase document. My lord, I am putting this.
No, they have not said so. They said
official document. This is not
there is no official document available which record the purchase of the raw jute from the petitioner, against which the checks have been wrongly issued by the hiring officer. Have they denied that it was never purchased? Kindly check.
My lord, this is not there. Even my lord, kindly have a look and page 12 to 15, the purchase document. It is not my document. It is the document of the JCI. Checks are not my document. The document belongs to JCI. There was no whisper that I am tampered any document.
No, my question is very specific. In your read petition, you have stated that you have sold certain quantity of jute, raw jute or something like that to the JCI. And the consideration money was not paid to you since a check has been signed by one of the joint secretaries. My specific question to you, whether in their affidavit in opposition, they have stated it specifically. Number one, those documents are forged documents. Number two, though the quantity which you have mentioned in your affidavit read petition supported by the annexures are not the correct one. Have they dealt with?
So far, my lord, my understanding and the reading of the opposition, as well from your lordship by two my lord queries, there is nothing whispered in it.
Very good.
Only they said paragraph 13, the purchase relied upon by the petitioner are dubious and does not seem to be genuine. Seem to be genuine.
Paragraph?
Paragraph 13. Internal page 5. Well, this is very interesting language used. The purchase tally memos relied upon by the petitioner are dubious and does not seem to be genuine. The purchase tally memo used in the period of purchase are of a series number 212, where the purchase memo relied upon by the petitioner belong to an entirely different series, being number 12. The memos are not genuine.
Very good.
So that amount,
Any other submission?
this is the only, they have denied only that, only they do this, that this purchase.
What you have stated in your affidavit in reply?
Alright, I have two. Paragraph 5, if you recall it, though I am not so happy with that. With reference to paragraph 9, 10, 11, 12, and 39, and
very good. Take your seat, sir. Yes, sir.
Lordship, Jute Corporation of India was specifically formed.
Yes.
To purchase jute from the distressed farmer. And every year,
yes, sir,
they set up a minimum support price. Minimum support price. If the jute prices fall below the minimum support price, Jute Corporation gives this support to the farmers that they can come and sell to us and we'll give them the minimum support price. A lot of Jute Corporation of India, for that matter, plays a very pivotal role in the jute industry. This jute, which is collected from the marginal farmers or farmers who are in distress, is then again sold compulsorily under package orders to the jute mills so that they can prepare this jute bags, sack bags, they're known as betel bags. Now we purchase this jute from certain purchase centers. Previously we had 140 purchase centers. Now we have around 110 purchase centers. In 110 purchase centers, the jutes are weighed and entered into entered into purchase register. And based on that, the checks are issued. Now we don't even issue checks. We have done away with the check system altogether. From there itself, we electronically transfer the amount.
Very good.
This is the role that we have been playing.
Hmm.
No, Lordship, the first question that I would like to ask myself is this: why did the accountant refuse to sign the check that day? Because he has been doing it. He just tallies it and issues a check. The manager signs the check, the accountant signs the check, and it is sent to the firm. They have mentioned certain amounts. I don't know what is the total amount. But Lordship, I say we purchase lakhs and lakhs of tons of jute from the farmers every year. Every year, throughout the year, we purchase jutes on MSP, and we purchase it to 110 purchase centers. Okay, I'm not going into the details, but in that purchase center, what happens is this: after the jute is purchased, they are then made into bales, and then certain things are done. Moisture
Those are
content.
not required for the disposal of the
But-
instant need petition.
Yes, every detail is. No, Lordship. See, Valentine Sangma, the manager who ostensibly signed the check, has previously also some disciplinary proceedings for excessive.
Basu, that is your internal matter.
I might be.
Whether question is whether
Please, Lordship, I understand. My submission is limited to paragraph 13, paragraph 14.
yes,
I have disputed it. I have said that the purchase tally memos relied upon by the petition are dubious. They're dubious. I deny their existence and does not seem to be genuine. The purchase tally cum memo book used during the period of purchase are of a series being such and such. But the purchase memo relied upon by the petitioner belongs to an entirely different series being such and such. So the accountant.
it is also within your control.
What control, Lordship? This purchase memo.
Which series number, which
Lordship,
series you will
on the
issue or
other
not?
hand, on the other hand, if I put the question to myself, that the petitioner and this manager had entered into a conspiracy to deprive the Jute Corporation of India.
Have you lodged any FIR?
I have not lodged an FIR, but that could, Lordship, that could also
Have
be.
you replied to their letter that
This
you
is
have
the
not
question
sold
of
it?
evidence, Lordship. This is the question of evidence. Is the court going to pass an order on a government company to pay for a jute that they have never purchased?
No,
If your
simply
Lordship
because
thinks
the
so, Lordship
government,
does it.
simply because it is a government
If-
corporation, it is not a,
If your Lordship
it's
thinks
not
so,
an exempted person.
I'm not an exempted person. If your Lordship thinks so, your Lordship passes an order. I'm not coming in the way. I don't want to deprive a purchaser also, a genuine purchaser also. But Lordship, why?
No,
But
have
the
you
only issue
ever
is,
taken the point, Mr. Basu? Please answer to my question. Have you ever taken the point, either by way of correspondence or while filing the affidavit in opposition, that those documents are forged document and it was never
no, I have said
sold?
this. I have said this.
No,
Dubious and does not seem to be genuine.
you have taken a evasive ground,
No,
evasive
this is
denial.
not evasive and does not seem that memos are not genuine. This is said it.
I understand you.
I have stated the memos are not genuine.
Take
Don't you
down.
please believe this fact that I have stated that the
Very
memos are
good.
not genuine.
I'll record your submission.
And also kindly note, Lordship,
By
kindly record my
filing the
submission.
instant,
Kindly record my submission that this week is
Yes,
not
yes, yes,
maintainable
yes.
because it's a question of evidence.
by filing Lordship will take up the original said matter. Will be taken up.
But may I have your lordship's kind leave to mention, my lord, two execution matters, my lord, upon notice to the other side, my lord. Here, my lord, what happened at when the judgment debtor was on box, some of his relatives and co-owners of a property on which some injunction was there, my lord, intervened and filed an affidavit of undertaking that they will pay off the entire decretal amount with interest within 3 installments. Yes, my lord. Order to the irrespective.
My lord, may I be permitted to mention one execution case, my lord? It has been settled, my lord, for listing, my lord, for inclusion in the list, my lord. Grateful.
My lord, it will appear on next Thursday.
Yes, my lord. Yes, my lord. Grateful. Grateful. Thursday. Grateful.
Lord, before my learned friend starts, I don't think she can press this. And I was just about to, my lord, let her press her application, then I make my. No, not just because of that. Your lordship's list is also very heavy, my lord. A similar matter on 6th February 2025, your lordship had taken cognizance arising out of the same order and fixed it, my lord, on the 6th of March. Because that was by the brother. This is by the two other sisters. Yes, I have. Let us not waste your lot of time. I don't want to waste my time, therefore I want to proceed with all these matters, my lord, they have a point of jurisdiction involved. So let her ask with the point of jurisdiction. And it cannot be done piecemeal, my lord. It has to be done together. It saves time. Section 47, in the nature of section 47, dismissal of the EC because it arises out of, my lord, because, my lord, it is the same order passed by the company court, where, my lord, decree has been passed by the company court. Now, from there, my lord, 3 applications have been filed, execution. One by the brother, that is Dipankar Banerjee, one by Shopna Rai, and the other, my lord, Sumitra Mukherjee. Now, all these matters, my lord, have a point of jurisdiction, that this court, my lord, does not have jurisdiction to entertain this appeal. It has to go to NCLT. Yes, my lord, that is the difficulty I am facing. Now, there are different obligations and different agreements. The elder brother has filed the execution application, that is, my lord, the sale of 3 properties. These 2 sisters have filed the application for payment of money. My lord, these 2 applications that are appearing before the lordship today. In the first matter, my lord, the sum of by me, that is, yes, for dismissal. And affidavits are complete there. Same point is there in that matter. The matter is ready for arguments. Not every time the matters come up. No, this is. Let lordship see. If your lordship says I should argue, I'll argue now. We'll keep everybody waiting. Here, 1 minute is my dismissal. Yes. J1, my lord. So, Dipankar Banerjee order gulo nahi. No. They have filed. The next matter, my lord, also same thing. The judgment gulo nahi hai Dipankar. Next matter, don't file any application. Their application I intend to file. But yes, if your lordship decides this, then it covers all the other matters.
Yes, kindly Milord takes and judgmental copy below one. My GA1. This has to be Milord read with the execution. The previous court was also Milord taking up all together. My first point, Milord. My first point, Milord, is that finally takes the tabular statement. Execution tabular statement.
Yes, tabular statement.
Kindly Milord takes the tabular statement and sees the properties. G.
Clause, column number.
G. In fact, Milord, first lordship takes Milord column number B. The judgment debtor be directed to file affidavit of assets, particulars of their assets and properties sufficient to satisfy the decree. Leave be given to examine. D. Necessary direction be issued to the judgment debtor requiring attendance for oral examination.
Madam, you are reading which portion?
Milord kindly takes the prayer G, which is Milord second page.
Yes.
It is also just and convenient that a fit and proper person be appointed receiver and the receiver so appointed be directed to take symbolic possession of the assets and properties mentioned in paragraph 19 till the time a prospective buyer is imminent. Now, they are asking orders, Milord, over properties which are in paragraph 19. Kindly, Milord, see where these properties are.
Yes.
Page 6
Page 6
of the EC, of the execution case. Decree holder has ascertained that the judgment debtor owns the following assets and properties.
Page 6 of the EC.
Yes, EC, my lord.
Paragraph?
Paragraph 19, page 6.
Paragraph 19 says the provisions of executions of decrees are, so far as they are applicable, be deemed to apply into the execution of the orders.
No, 1 minute. Which am I reading? Swapna. Oh, I should. Oh, it is this. Sorry.
We are on Sumitra Bhattacharya versus Shubhankar Banerjee. EC 10.
10.
Let me, please
That
show
is
me
why
the degree first. Madam, please show me the degree first.
Yes, I'll show the decree. First, Milord, I was showing this because the properties are all outside. Milord, kindly once again, Milord, take this, Milord, paragraph 15 of this EC.
Paragraph 15.
Yes.
Yes.
The decree holder has ascertained that the judgment debtor owns the following assets and properties. Land at Mauza, Sandipur, PS such and such. Land at GS Fort such and such. One is Howrah one is, my lord, some other, all, my lord, beyond the jurisdiction of this honorable court. And this, your lordship will see the details of these are at page 23. This, my lord, is the decree, which is the terms of settlement. I'll show that now. Page 20.
Terms of settlement has formed the part of the degree.
Yes.
Very good.
And this, my lord, is the part of the terms of settlement, page 23. First property, property at 8/8 Baligan Station Road, Kolkata 19. Second property, my lord, is Howrah. Third, my lord, is somewhere in AJC Bose Road. Fourth is GS. Now, para 15, I have shown, my lord, two properties. Howrah and GS Road. Those are, my lord, at serial numbers 2 and 4 of page 23. Has, my lord, your lordship got that?
Yes.
Yes. So my first point, my lord, is that this court lacks territorial jurisdiction to execute the decree.
No, what is the, tell me,
Now,
what is, just a minute, madam.
Yes.
What is the nature of the degree that I intend to see?
Kindly come to page 11
Page 11 of the GA.
of the execution. It is there.
I'm sorry, execution case.
Yes. This is, my lord, a 10F appeal. My lord, what happens, my lord, in that time, my lord, there was CLB, Company Law Board, which passed, my lord, an order under the relevant sections for mismanagement. An appeal was preferred from there. Family dispute over companies. This is the order. May I place this, my lord? Page 11. I'll show the relevant provisions also. My lord, this 10F appeal has been filed from order dated 22nd February 2008, passed by the Company Law Board, New Delhi, in CP number 74 of 2005. Has your lordship got that, my lord?
Yes, yes.
A settlement has been reached between the appellant number 1 and the company represented by the respondent numbers 2 and 3, and such settlement is recorded in the terms of settlement, which has been signed by both the appellant number 1 and on behalf of the company and their respective advocates. Let such terms of settlement be filed in court, and by virtue of such terms of settlement, all disputes between the appellant number 1 and the company stands resolved. The appellant number 1, by virtue of the said terms of settlement, has agreed to relinquish his right, title, and interest in the office space along with the car parking space for a sum of rupees 94 lakhs. This is not my learned friends. This appellant number 1, my lord, there was Dipankar Banerjee, which your lordship will find from the cost item. The appellant number 2 was represented through her husband, the appellant number 1, and it is submitted by counsel on behalf of the appellants that she has no claim as.
So you are not here.
No.
Then you are appellant number 4.
I am not, they, it's them. Tumi kon appellant chile? 4. So appellant number 2 was represented through her husband, the appellant number 1, and it is submitted by counsel on behalf of the appellant that she has no claim as against the
No,
company.
who is the judgment in this case?
The judgment, I am the, in fact, my lord,
Shubhankar Banerjee.
they say so. That is another point, my lord, I am not.
Shubhankar Banerjee was not a party to the said appeal.
In the capacity as a director of, my lord, HTC.
Okay. Shubhankar Banerjee was there.
Yes.
As a respondent number 2.
Yes.
So what order has been passed against the respondent number 2? That I intend to see.
That my lord, the settlement, that we will come, my lord, next paragraph. A settlement has also been reached between the appellant number 4 and the company. Kindly note this, my lord. These are very
So
important.
appellant number 4 is the degree holder then.
There, have them.
So you are the appellant number 4 before me. Very good.
And the company, not Shubhankar Banerjee, my lord.
Very good. Let me see.
The terms of settlement between the company and the appellant number 4 has been signed by the parties and also their respective advocates. Let the terms of settlement between the appellant number 4 and the company be taken on record.
Very good.
So this
Let
will
us
be
let
on-
us concentrate on what is the terms of settlement between the appellant number 4 and the
Then that is, my lord, then, my lord, if that is really executing the decree which my learned friend must show. I don't have, I am only, my lord, saying it should be dismissed. On merits, I say nothing is due and payable. So let my learned friend show, my lord, what was due to them.
No, it is your application. You move.
My application should be dismissed on the ground of lack of inherent jurisdiction, subject matter jurisdiction, territorial jurisdiction. I will say, my lord, whether due or payable or not, this court has no jurisdiction to get into that.
Why?
Because the properties that they seek to execute today, which is from the tabular statement, are outside. This is an order passed, my lord, under 10.
No, in the event, the property of the judgment debtor lies in the territorial jurisdiction of other court, the degree will be transferred to that court for execution. So where is the provision for dismissal of the execution?
Provided,
Show me the provision in the order 21.
I'm showing. This is a company court order, my lord, 10F appeal order. This court has no jurisdiction. Let me show that. Kindly, my lord, takes the CPC.
Company law board.
See,
Company law board is still in existence.
Yes, and in the nature of NCLT now. And there is specific provision that the NCLT will execute orders of.
Show me the law.
Yes.
Okay, আছে, CPC আছে. So when an appellate court passes a judgment or degree, whatever may be, that degree merges with the order of the learned trial court. So you have to show that this court sitting in the original jurisdiction ought not to have executed the degree.
Cannot execute the degree.
Very good. Show me the law.
That is my case. First, my lord, I want to show the CPC. Finally, my lord takes section 37A. Also, my lord, this point in the other reason in the other matter, my senior was arguing. I did not want to also usurp that jurisdiction. But since your lordship, my lord, insisted, I am proceeding, my lord.
Please.
Your lordship will see Mr. Avojit Mitra was up here. 37A. Definition of court which passed the decree. The expression court which passed a decree or words to that effect shall in relation to the execution of decrees, unless there is anything repugnant in the subject or context, be deemed to include A, where the decree to be executed has been passed in exercise of appellate jurisdiction, the court of the first instance.
As I said.
That is my case. I will show case law. Court of the first instance, my lord, was CLT.
Come to the next clause.
Where the court of the first instance has ceased to exist or to have jurisdiction to execute it, the court which, if the suit wherein the decree was passed, was instituted at the time of making the application for the execution of the decree, would have the jurisdiction to try such suit.
So company law board has
Now
ceased to exist.
No, but now it has become NCLT. National Company Law Tribunal.
Where the court of first instance has ceased to exist or to have jurisdiction to execute it. The court which, if the suit wherein the decree was passed was instituted at the time of making the application for the execution of the decree, would have the jurisdiction to try such suit. So clause B is very clear. This court will have to execute the decree.
Sir, I have decisions to show, my lord, where the court of the first instance has ceased to exist or to have jurisdiction to execute it. So when it ceased to exist, it was replaced by NCLT. It is not that today there is no company court jurisdiction at all.
Please place clause B once.
Yes, I'm reading that. The court which, if the suit wherein the decree was passed was instituted at the time of making the application for the execution of the decree, would have the jurisdiction to try the suit.
Very good. So, where the court of instance ceased to exist, as in this case, or to have jurisdiction to execute it, That is the court which, if the suit wherein the degree was passed was issued at the time of making the application for the execution of the would have the jurisdiction to try such suit.
But if that court was still there, NCLT is there. When they filed it, it is not like that there was no.
Show me the law of the relevant law that the NCLT with the NCLT has the power to execute the degree of the company law board. Show me the provision. I shall dismiss your dismiss the execution application.
Yes. There are many other things also, Milord, to show. Kindly, Milord, take.
No, ma'am. Please answer to my first question.
Yes, yes.
You have raised the question of jurisdiction with regard to the executability of the degree by this court. Please satisfy, then go to the other point.
Kindly read the explanation. The court of the first instance does not cease to have jurisdiction to execute a decree merely on the ground that after institution of the suit wherein the decree was passed or after passing of the decree any area has been transferred from the.
This has got no application. This has got no application.
In every such case, such other court shall have jurisdiction to execute the decree. If at the time of making the application for execution, it would have jurisdiction. So today your lordship is saying, Milord, just because CLB was just.
Ma'am, I'm not saying.
Yes.
Just show me the law that now NCLT has assumed the jurisdiction to execute the decree. I shall allow your prayer.
NCLT.
Otherwise, you will face the cost.
Yeah.
Show me the relevant law.
Yes, kindly.
That I intend to see. You are simply to say, you are simply to show that admittedly, while passing the appellate degree, it merges with the degree of the original court.
Yes.
That is the company law board. Now, so company law board is the executing authority, executing court. Company law board has ceased to exist. So therefore, you have to show that the NCLT has got the power to execute the decree.
I'll show. নতুন বই দাও কোম্পানি 2013 না কোথায় there are few sections 408 Milord which says that Milord with effect from 1st June 2016 Milord NCLT was constituted and there are rules Milord 56 57 of the NCLT rules which gives Milord powers to the NCLT to proceed with the proceedings which the CLB was continuing. Yes, there are.
It will not. It has got no application. It has got no application.
I'll Milord show 430 of the Companies Act also, Milord, which says ouster of civil court jurisdiction. Kindly takes Milord section 430 of the Companies Act, Milord.
And you please hand over the book.
Yeah, I just have one book. That also I
place the order. I shall see.
Borrowed from my learned.
Show me. Place the order. Place the section.
Yes. No civil court shall.
It is section
430
of the Companies Act.
Yes.
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or the appellate tribunal is empowered to determine by or under this act or any other law for the time being in force, and no injunction shall be granted by any court or any other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or any other law for the time being by the tribunal or the appellate tribunal. Kindly, Milord, seize this. I'll hand over, then I'll show some other for you. And with this, Milord, also 408, the central government shall by notification constitute with effect from such date as may be specified
A tribunal to be known as the NCLT consisting of the president and such number of judicial and technical members as the central government may deem necessary to be appointed by the notification to exercise and discharge such powers and functions.
Ma'am, it is your specific contention that company law board has been replaced by the NCLT. So NCLT has the power to execute the degree. Show me the relevant provision that I intend to show.
So that specific, if it is constituted and there is a notification, it means not everything. It does not have to say, it has been clarified by judgment. The law cannot be black and white. We have to interpret the provisions and then
Very
come to a conclusion.
Show me the law.
Kindly, my lord, takes and your lordship has to decide this. 430, 408.
Very good. Let me see.
And this is the first point. Second is, my lord, even properties when outside, then your lordship will have to transfer.
Yes. Then why dismissal?
No, but this is, my lord, this is subject matter jurisdiction is not there, my lord, in my humble submission. If your lordship takes up and passes an order, my lord, it will perhaps, my lord, be a nullity.
Very good. Any other submission?
Yes, I have this, judgments.
Yes.
No, but I don't want to, my lord. I have a leader. Don't want to take it on myself
No, no.
completely.
You are sufficiently
No,
senior.
I
So
have clients have engaged a leader.
very good. Let them
My lord,
engage,
there
but I am
is
to.
634. I have decisions to show.
Yes.
বইটা দেখান একবার। In addition to that, my lord, is section (634) capital A. of the 1956 Act.
এই অর্ডার শিট গুলো এখানে আছে, এটা না?
Which, my lord, the Companies Act 1956, my lord, gave the power that the CLB, my lord, will be the body to execute decree. Of course, when it is now extinguished and a new body has come, my lord, this is automatically incorporated, my lord, by the law of incorporation in the new act.
This is a mode of executing a degree by a company law board.
Company law board. Now, when company law board has gone, this is 1956 Act. Then the 2013 Act came in, which I showed the provision which specifically ousts every other jurisdiction of all other civil court.
Very good.
Then, my lord, if that is the case, if civil court cannot do it, then, my lord, is this maintainable? By default, my lord, it has to go to NCLT. There is no specific, my lord, section required.
Very good. Any other point?
Yes, many points, my lord. Your lordship has to, my lord, allow me, my lord.
The Companies Act 1956 has been repealed with the enactment of the new Act of 2013
Yes. And which says that civil court will have no jurisdiction
that you have submitted.
under, my lord, 430. And when 10F, my lord, when the court passed an order, it was a company jurisdiction.
Very good.
That I will show, my lord. Kindly takes that 1956 Act, section 2, subsection 11. Civil court, if today this court, my lord, executes, it will be usurpation of that jurisdiction. For example, my lord, may I give an example, my lord? Arbitration Act, my lord. It has to be a deemed decree. But today, your lordship's court cannot execute that. It has to be the arbitration court, my lord, executing that decree. Similar, it's these principles which have to be incorporated. So when the Companies Act specifically, my lord, excludes the jurisdiction of a civil court, similar to, my lord, section 5 of the Arbitration Act, which says no. So just because, my lord, this court is in this building does not mean, my lord, it will have a jurisdiction. Or if had your lordship had passed that order, my lord, under 10F, that order was passed not in this executing jurisdiction or any appellate court jurisdiction. It was passed in the capacity of a company board appeal jurisdiction. And that, my lord, in my humble submission, my lord, has to be done and executed, my lord, by the appropriate forum which is available. Not, my lord, by any court. Even if it is the original site. Kindly, my lord, takes 211.
Yes. Ma'am, why are you showing the relevant provisions of the repealed act?
No, I am showing that a provision, my lord, of this act to show what was the capacity or the jurisdiction in which the 10F order was passed, the decree was passed. It was not a civil court order.
No, it's absolutely.
It is a 10F order.
Question is whether in absence of the executing court, that is a company law board, whether this court has power to execute the decree which has been passed by a company law board. That is the question to be decided by this court by virtue of your application in GO1. Am I correct?
Yes.
So why a repealed act of 211 is necessary?
It is necessary because, my lord, 10F maybe not necessary, my lord, to show if 10F appeal order was
Not
passed.
required, madam. In my view, it's not required. Come to the next point.
Then, my lord, we are consensus on one point that the 10F order was passed by the court of company jurisdiction. Today, what is playing, my lord, the problem is that 37B. Your lordship is saying that because CLB does not exist, my lord.
I'm not saying anything. I've not opened my mind.
Right.
I'm making a conversation.
Yes.
My finding will be reflected in my judgment and order.
Yes, I will also address your lordship, my lord, on what exactly I have to address. But I would say, my lord, 37A applies here because NCLT, my lord, has today been taken over the jurisdiction of the CLB. And when this was filed, Decree, my lord, 2012, they are coming, my lord, after almost just a day before, my lord.
Very good. I have understood your submission.
No,
Take down.
Orders.
Show me.
My lord, kindly not do this, my lord. There are 3 more matters which have to, my lord, all have to be decided, my lord.
And let me decide what I am to do. You place your case.
Very well, my lord. Kindly take 2004 Calcutta 141. My lord, this perhaps, my lord, is a little more complicated. And, my lord, your lordship will have to be the first one, my lord, to decide this. This will be the first case after, my lord, the CLB has come. Because all other matters on a regular course is going there.
I am honored.
Yes. So, my lord, I should also, my lord, be given that time to kindly take.
I have no help. That's the problem. AIR 2004 Calcutta 141. I'll give you a lordship the judgment I have. This is under the, this interpretation is required because this was under the previous act.
Yes.
I am taking below the principle of this. Where below it was a consumer court case, how section 37A below was interpreted. Finally, below C. Para 1. None appears to oppose the writ petition. The grievance of writ petitioner in this case is that the orders passed by the State Consumer Redressal Forum while exercising appellate jurisdiction cannot be executed by the State Commission. Mr. Naik appearing for
Ma'am, why it is relevant? Because in this case, the State Commission made an attempt to proceed with the execution case while modifying the order of the District Commission. The Calcutta High Court says, no, when the appellate court, this State Commission being an appellate authority, modified the order of the District Commission, it is the District Commission to execute the order, modified order, not the appellate authority. So it is not, I am not an appellate authority. Question before this court is whether this court in sitting in original jurisdiction can execute the degree passed by a company law board. According to you,
Yes.
company law board has been abolished by the Act of 2013. In its place, the national NCLT has come into play. So NCLT assumes the jurisdiction to execute the degree if they are real.
Yes.
And you have shown the relevant provisions of the Code of Civil Procedure, Section 37, that it cannot be termed as a court of first instance within the meaning of Section 13B of the Code of Civil Procedure. The matter is as simple so far as I have understood.
Yes.
So don't waste my time and please allow me to dictate the order. Take your seat.
But Millard, if your lordship is not with me, then I will have to, Millard.
No, ma'am. I shall pass order.
No, kindly.
Take down.
Another decision.
Show me.
And this is one also territorial is there. Thousand five. Here also, Millard, it also has to be, Millard. I'll just cite it just in case, Millard. Para 15 and 18.
What is the citation, madam?
2006, volume 132, company cases 503. This is, Millard, to show that the intention is that it will be the court of first instance. And Millard, specific, Millard, whether NCLT execution power, Millard, I will have to then check what your lordship is saying. After it has come. Finally, also, Millard, sees order 21, rule 11.
এই এসিটা চালাতে বলুন।
Yes.
এসি
My lord, I have to, my lord, check the NCLT rules once.
Check, I shall pass order. Any other point, madam?
Yes, my lord, NCLT rules 2016. NCLT rules 2016. Rules. Yeah.
NCLT rules
16.
Madam, my question is very simple. You are to show that with the enactment of the new Act of 2013, all the judgments and orders which has been passed by the Company Law Board has to be executed by the NCLT. That means the NCLT assumes the jurisdiction of the previous Company Law.
No,
Matter ends.
that is there, my lord, 434.
That you have shown. Don't show again. I've seen.
No, 434. Kindly takes, my lord, section 434.
Please.
Transfer of all pending proceedings.
Can it be called a pending proceeding?
Certain pending proceedings, and as on the date when the NCLT has come, or everything has to be there.
It's a new execution case, madam.
Also, my lord, new ones also will be there. Kindly, my lord, takes this provision. My lord, pending only has to be specifically said. But if, my lord, it is there, if a forum is there, new, my lord, by default has to be there because 430 bar
Very good. Let me see.
of this court. The confusion arises, my lord, when a new forum is created.
You have confusion. This court has no confusion.
No, I am saying that the jurisdiction.
You may have confusion for the interest of your client, but the court is absolutely clear.
You know, when a new forum is formed, it definitely means, my lord, everything should be there. That's why, my lord, specifically pending proceeding has to be transferred. It does not necessarily, well, I am not understanding this part.
Take down. Sorry. No more submission. You want to give reply? You want to give reply? Please, very good. If required, I shall accept your reply after passing of the order. Listen to my order.
My lord, I also have a point of, my lord,
I have
territorial
that's all.
Territorial jurisdiction.
Look, GA1 of 2024. By filing the instant application, you have filed your reply. No affidavit reply today. The affidavit reply as filed today is taken on record. By filing GA1 of 2024, the judgment debtor has basically prayed for dismissal of execution case number 10 of 2024 as not maintainable along with other ancillary reliefs. Stop that. You are Madam Banerjee, no?
Yes, sir.
MS Banerjee, learned advocate, appearing on MS Banerjee, Learned Counsel, appearing on behalf of the judgment debtor / petitioner in GA1 of 2024, at the very outset, draws attention of this court to the tabular statement as has been filed with the instant execution case. Attention of this court is also drawn to the certified copy of the degree which is sought to be executed in the instant execution case. It is submitted by MS Banerjee that from the certified copy of the degree, it would reveal that this High Court, sitting in appellate jurisdiction, while entertaining an appeal under section 10F of the Companies Act 1956, hereinafter referred to as the said Act of 1956, from an order passed by Company Law Board, Principal Bench, New Delhi, had modified the degree passed by the Company Law Board in terms of the settlement as filed in the said appeal. Order. Yes. কি লিখলাম বলতো? Modified the order passed by the as filed in the said appeal. Full stop. Para. In our next folder submission, MS Banerjee, Learned Counsel, submits further that with the enactment of the Companies Act 2013, the said hereinafter referred to as the said Act of 2013, in short, the said Act of 1956 have been repealed. Full stop. It is further submitted by her that with the enactment of the said Act of 2013, National Company Law Tribunal, within bracket NCLT in short, has been created, which assumes all the jurisdiction of the company law board
Shubhankar Banerjee and between Mr. Bhattacharya.
Hmm.
Mr. Bhattacharya is good.
Hmm.
Now, my lord, the kindly take 660 of my application. That's the next page. Shubhankar Banerjee deceased during his lifetime along with his son, eldest son, Shubhankar Banerjee, Vikram joined by his younger son, developed several business partnership firms with private limited companies. Thereof are set out in schedule numbers, in serial numbers 1 to 7 serial number, and have also acquired various similar properties in serial number 1 to 5.
Very good. What do you want, madam? I have gone.
From the settlement, so will kindly change page number 23. Page number 23.
I'm already on there.
Yes, madam. Second, item number.
You need an injunction.
Sir, I would be asking for an order of injunction and not asking them to file an affidavit of assent.
Very good. Take down. Very good. I understand.
No, my lord, I have to, my lord, oppose the injunction, my lord. He is asking for injunction over properties which are outside. That is, my lord, my second point. First was subject matter jurisdiction. Second, my lord, is territorial jurisdiction. My lord, there are judgments of our High Court, which says, my lord, no order of like this nature can be passed, my lord, when the property is outside. And her claim, my lord, is really
Very good. Let there be an ad interim order of injunction for the time being.
what basis she has to prima
Very
facie
good.
show. No, let prima facie has to be shown. I am not supposed to pay her any money. Kindly see, it is only after selling of the properties her claim arises. No, kindly may not see that. I have
Ma'am, in an execution course, you are not supposed to reopen the degree. I'm bound by the I'm bound by the degree.
I'm showing the
You
decree.
know that the digital court cannot go behind the degree.
No, I am showing the decree on
What will happen if you dispose of the property?
it's
They will become infractuous.
supposed to be disposed and then paid. Kindly see, my lord, the decree, page 16. Kindly see what is her claim. Page 18, paragraph 2. The second party would be entitled to receive a sum of rupees 25 lakhs only, which will be paid to her after realizing from the sale proceeds of the properties mentioned at 1, 2, and 4 of the second schedule.
Page.
Page 18, my lord, para 2. Which is why, my lord, this thing is coming, para 2. The second party, which is my learned friend, for number 1, my lord, is complied. I have given her a flat. Would be entitled to receive a sum of rupees 25 lakhs only, which will be paid to her by Shubhankar Banerjee, realized from the sale proceeds of the properties mentioned in serial numbers 1, 2, and 4 of the second schedule. The allocation of one flat on the first floor and the payment of 25 lakhs only will be paid.
1, 2, 4.
Yes, now that is, my lord, at page 23. And this has to be sold. These are supposed to be sold. If your lordship is passing an injunction that is contrary to the decree. Now, number 1, my lord, she is not allowing me to sell. She has on a portion, my lord, created a third party interest, which is why, my lord, I am not being able to sell that. With regard to 2 and 4 also, my lord, there is absolutely no help. On the other hand, my lord, they are creating trouble, my lord, in selling. If these today, my lord, have to be sold and then she will have to be paid. That order, my lord, in my humble submission, my lord, can this court pass a direction to execute sale of these properties in Howrah? That is, my lord, my first, that is my point. There is no monetary transaction in this decree by which, my lord, I will pay from my pocket. This was all family assets, my father's assets, and, my lord, they were to be sold and, my lord, distributed. For 12 years, my lord, I cannot sell because she is creating trouble. She has, my lord, created third-party interest on every property, where now, and my lord will also appreciate. I am also supposed to get some money out of this, not just her. I am not being able to sell this. She has today come to court asking me to pay from my pocket, my lord. How is that equitable, my lord? This is a jury court of equity. Now, kindly see, my lord, 3, page 19, my lord, 3. Again, it says.
Oh, our prayer is very innocuous. Read the paragraph F.
Paragraph F.
Paragraph F. Read.
I am showing the decree. This court can't go beyond the decree.
Yes, I am not. I don't want to go beyond the decree.
Decree says it has to be sold, which is para 2, page 18. Then again, my lord, page 19, para 3. It is hereby agreed. Page 19, my lord, para 3. It is hereby agreed by and between the parties hereto that a sum of rupees 25 lakhs.
Very good. You identify a prospective buyer. I will vacate the injunction. We will allow you.
Milord, no, Milord, Milord, kindly see, Milord, if there is an injunction that is contrary to the decree. Now, Bhaskar Bhattacharya's judgment, no. Milord, there is a clear judgment of our High Court which says.
Prayer is very innocuous. Till a prospective buyer is identified. You identify the
Then this court will pass. Lordship will send it to the appropriate court for such order.
No, ma'am. I have power. It's a digital code.
Milord, I am showing.
It's a digital code.
Milord, kindly see, Milord. Then why an injunction? Let us find a buyer, Milord.
Very good. Ask your client to find an undertaking that he will not carry out.
I don't know why this hurry. This is after they are coming.
The court is in hurry.
Yes, they are coming.
Court is to secure.
Court has to secure, Milord, the overall, not just this woman, Milord. There are three matters.
Mind it, madam, you are a judgment debtor, and not you are arguing before an appeal court. You are arguing before a executing court.
Executing court which says there has to be sale of the property.
Huh.
Today, Milord, down order.
In the event you sell up to a third party, what will remain in the degree?
Your Lordship is passing an injunction, Milord, on the property. Then, Milord, who will get the prospective buyer?
Very good. Take down. I have heard you.
Milord, I have judgments to show this.
Very good.
Pass.
Yes. Really good. In course of his submission, I will record your submission. In course of his submission, here a GA te likho. Learned advocate for the degree holder at the very outset draws attention of this court to you have shown which paragraph of the agreement? Terms of settlement?
Paragraph 5, 6. In fact,
Page.
19 and 20.
Yes. কি লিখলাম?
Milord, my learned friend, Milord, in when this was yes, Milord, I have found this decision.
To page number 19 of the execution application. It is submitted that in terms of this settlement, as filed before the appellate court, the present judgment debtor, Shubhankar Banerjee, is duty bound to pay rupees 25 lakhs by sale of properties as mentioned in serial number 1, 2, and 4 of the second schedule
Sir, may I take the judgments back? Those were the only copies I have.
No, no, you will get it back, but after recording, signing of my order.
Hey, affidavit of
I do not comply with, but similar order may be passed only here without what? Some of them 70 lakhs is to come. You have paid 10 lakhs, obviously you want to pay for the safety. Your money. Same judgment letter.
No, this is no affidavit, nothing. He has filed it. I have only.
देखिए फाइल दिन तो as per terms of settlement, what the judgment is supposed to do in respect of the second schedule property in 1, 2, and 4.
Which 2 is already sold off, not giving me it. Executed promissory notes in my favor. Everything is there. Lordship will kindly take page 20.
No, here where is the order? Show me the terms of settlement. Page 14.
Terms of settlement.
Where we will get the name of Shopna?
At page 15, Shopnara.
Yes.
Shopnara is the decree holder over here.
Yes.
Similar fact, same matter. But terms of settlement. Come to page 17 of my application now. Shopnara is to get a sum of rupees 25 lakhs, which will be realized from the sale proceeds of property mentioned in numbers 1, 2, and 4. The payment is by form for balance. A part payment of Shopnara's full and final settlement.
Same order have
Like clause 2 now. Hereby agreed the party with the initial sum of rupees 25 lakhs shall be paid by Shubhankar Banerjee by sale of the property mentioned in numbers 1, 2, and 4. All efforts to be made to sell the property mentioned in number 1, 2, and 4 within 6 months. Now, Lord, there is a simultaneous memorandum of agreement which is executed this agreement where Lord it records the balance sum of 45 lakhs how it is supposed to come.
Well, that is not a decree.
It is actually
Whatever your lordship then will pass, will pass.
For the timing, let there be an injunction. Hey, what a same order. Same order in respect of injunction, restraining the judgment letter from alienating or such and such in respect. Coding. 70 lakhs. Where from will get that? Call the next matter. Ma'am, those have been, I said it will be getting, don't be worried. I've recorded, no.
Any order. Now I'm very worried.
About the book. So judge is supposed to pay a security, give a security.
Executing court for this. No, then Milan, later on I will.
Please.
This is a matter execution case for one line.
I'm doing one thing. So for item number 3 and 4 is concerned, I'm making it not today because the criminal appeals have to be taken up.
Minor will standing only one spot. You just insert one line.
No, I'll not grant anything because so many matters of the criminal lawyers are waiting. Criminal practitioners are waiting. Hey, একটা কাজ করুন। For item number 3 and 4, not today.
Lordship, for item number 4, can it be kept for Monday?
It will come on the next Thursday.
Next Thursday.
The rectification is that way also it can be taken up in the next.
We'll just rectify it.
Only take one.
Next Thursday তে আসবে।
Lordship, item number 4 is appearing for.
All the appellate side matter, criminal matters.
The Lordship, and for the applicant. Senior advocate Shikhar Kumar Bhatt is also
Main cases as well. We are also pleased to appoint the two of us, Malay, as a micus to represent the appeals. Hello, Malay, Miss Hussain is for the state. Miss Hussain, Miss Faria Hussain is for the state. There's another junior for the state. Very good. Mine. But it's a conviction under section 307 and 34, my lord. Dispute between neighbors. There was a scuffle. Two cases lodged. One by the present appellant. One by the present appellant and another against the present appellants. Conviction in the other case as well. Conviction in this case as well. 307, 34. But there are two appellants. The case was against three people. One, the lady accused, my lord, she was discharged. The accusations against her was improbable.
acquitted, my lord. I stand corrected. Acquitted after the trial, my lord. The two male members of the family, my lord, they were convicted under 307. There's an injury report which says that there's a shoulder injury. Two entire families, my lord, accused of they were neighbors, my lord, on the same line, consecutive houses. The dispute is, my lord, the allegation is that very well, my lord. Great.
That we tend, my lord, I tender my apology because, my lord, we are in such a mess now. Two bail courts, 3 bail courts, that also from 2 p.m. My lord, we are in such a mess, and running to that building and coming back here is becoming very difficult. Here, 26 is sitting right that side where the chief court is there. I need, all my hands are busy now. That is the difficulty. এটা 79 আরে আমাদের কাছে পেপার বুক নেই ওই তো পেপার বুক গুলো আছে কবে পেপার বুক করলাম ও with regard to item number 79, my learned friend has got the paper book today morning. My clerk still couldn't get the paper book. Five.
That is item 7.
Item 79. He collected today morning. My lord, we couldn't collect today.
That is a problem because we had gone to the department last day. Your lordship has appointed me and I made sure that I have gone through it. I have gone through it in detail. Malad, I can do the matter if your lordship wants to clear it out. But Malad,
I do not have the mal. আর কালকে তুলতে পারবে তো
it has been alleged that the police never took their document. My lord, one person was hospitalized against based on which the conviction was held, my lord. The allegation of injury was against two other persons as well. It was alleged that one lady who was in the advanced stages of her pregnancy was also assaulted. Malik Sridham Maji
Is the father of
father of the complainant who allegedly suffered the grievous injuries based on which the conviction has been upheld. Pilot, that is pilot 2-inch cut pilot, that's on the forehead. And forehead pilot. And the other injury pilot, the fracture that is on the right shoulder. It has been alleged that the second appellant pilot, Hiren Maji, he had assaulted Sridham with a rod on the right shoulder, which allegedly caused those fracture injuries. And the other cut pilot on the forehead was a result of being assaulted with an axe by Ajit Maji. On the right shoulder. The second opinion.
no, the other person, what injury?
But it was alleged that the other person was assaulted by a lathi and he fell to the ground. But that has not part of Sridham is the only person who has been medically examined and it has been found that he has two injuries on his person. One on the forehead and one on the right. What about the other injured person? No, man. He has been hospitalized. There is no injury to the other injured person? No, man. No injury. No medical evidence. The medical officer. There are three injured persons. Only Sridham Maji. But my lord, it was not produced. Just the injuries suffered by Sridham. Fine. Well, then take your lordship to the FIR first, my lord. The 156.3 petition, my lord. If your lordship my lord, before we go to the 156.3 petition, my lord, if your lordship takes up the formal FIR in page 1, page 4, my lord. Page negative 1. Well, your lordship knows the time of the injury, my lord, the occurrence of offence, Saturday, date 17th May 97, time mallet at about 3:30. Now this time is a little bit relevant one. The lordship also notes that the case was started under sections 341, 323, 324, 327, 325, 326, 307 and 34 one. Now mallet, your lordship kindly comes to the 156.3 complaint, which is inner page 3 one. But I start from paragraph 2, where the narration is there. That on 17/5/97, at about 3:30 p.m., while the complainant and his brother, P.W. Kalachand, were in the eve of plastering their outer wall adjoining the Coolie Road, the accused persons raised objection, and all of a sudden, accused number 3, Sottavati, caught hold of such and such of Kalachand and began to pull rudely, whereupon Kalachand raised alarm, to which his father P.W. Sridham came for his rescue. The accused number 2, Hiren, assaulted P.W. Sridham on his right shoulder by an iron rod, causing severe injuries, and in the meanwhile, accused Ajit brought out an axe from his house and violently assaulted P.W. Sridham on his head with intent to kill him, whereupon Sridham fell down with severe bleeding injuries. PW Shonjoy intervened for separating the parties when Khudiram, the father of accused number 2, assaulted PW Shonjoy, brother of PW Sridhar, by lathi, causing injuries when Shonjoy pushed him down by way of self-defense. PW2, Srimati Subhodra Maji Gop, wife of Sanjay Maji Gop, also came for the rescue of her husband, whereupon accused Hiren assaulted her by a lathi while she was in advanced stage of pregnancy. So, my lord, these are the three injured persons as per the allegations, my lord. The first one is Kalachand, which is the first is Kalachand, my lord. It is the allegation Chodobot. Kalachand. Thereafter, my lord, his father comes to rescue him, Sridham, upon hearing his human cry. Right. My lord, now when Sridham comes to intervene, Sridham is allegedly assaulted by Hiren and Ajit, who are the appellants before your lordship. First assailant is Hiren, then by Ajit. Hiren with an iron rod, then Ajit, and thereafter Ajit with an axe. Thereafter, my lord, when the wife of Sanjay Maji, Subhodra Maji, comes and intervenes, who was in her advanced stage of pregnancy. My lord, this is important because it has been observed in the impugn judgment as well. While acquitting the other accused, my lord, that she was allegedly Hiren, my lord, but Hiren was, but this particular allegation was not considered because I'll just skip to that relevant part, my lord, because she delivered a healthy baby within 1 month. So it was observed by Kalachand was assaulted by allegedly by Shoto. Are the accused person? Yes. Convicted only on the basis of injury suffered by Sridhar. All the other allegations, my lord, were observed, has been observed, considered by the learned court below, my lord, and has been stated that it is improbable. Those allegations are not corroborated, not substantial. Sridhar. Sridhar. Thereafter, my lord, paragraph 3, that the accused person as a safety valve also lodged a counter information at Adra IC, and in course of investigation, the PWs 1, 3 and 4 had been arrested as accused persons. Case and counter case, my lord, the case registered first, my lord, was the case lodged by the present appeal. The instant case, my lord, was lodged after 50 days. Thereafter, my lord, I continue in paragraph 3. Accused Lahu Maji had been released on bail, while other accused persons who are PWs in this case are still in jail custody. That injured PWs lost information at Andhra IC, but nothing was recorded in their presence, nor any action taken against the accused person immediately. The police personnel assured to investigate their grievances, but nothing tangible has been effected so far. The male injured persons are still in jail custody, hence the complainant.
So, Mr. Ghosh, paragraph 3 and 4, I'm sorry for interrupting you. Paragraph 3 and 4, according to the prosecution, is the expansion with regard to the delay.
With regard to the delay, minor, which has been contradicted in the evidence.
Contradictory in the evidence.
The deposition.
Show me the evidence. Show the relevant portion.
Note, my lord, this portion of paragraph 3, where he states, the complaint states that the other accused persons who are PWs in this case are still in jail custody. Thereafter, my lord, this part of paragraph 4, my lord, the male injured persons are still in jail custody, hence the complainant has been obliged to file this case at this belated state, for reasons stated above. This is the explanation for the delay as rightly observed by your lordship, my lord. This which has been contradicted, I'll show you. My lord, thereafter, the next page, my lord, is the learned judge bringing charge against the accused person, my lord, wherein the learned judge has framed the charge under only section 307 and 34. All other sections are wrongful restraint, simple hurt, all my lord, charges not framed. Thereafter, my lord, we come to 1.
No, Mr. Ghosh. Read the charge. It is also vital.
Right. I shall charge of it. I such and such hereby charge you as follows.
Such and such.
Thereafter, my lord, hereby charge you as follows. 1. Ajit Maji Go. 2. Hiren Maji Go. 3. Shottogoti Maji Go. That you on or about the 17th day of May 1997 at village Beko, hill station Kashipur district India, in furtherance of common intention, in an act of assault with such intention or knowledge and under such circumstances that if by the act there is there is
Yes.
written below, you had caused the death of Sriram Maji Go and Sanjoy Maji Go, you would have been guilty of murder and that you caused hurt to the said person named above, and I again go trial and murder, and hereby committed an offence punishable under section 307 of the
So according to the charge, there are two victims, Sridham and Sanjay.
Sridham and Sanjay.
But we find Kalachand, Sridham and Subhadra. So where from Sanjay comes?
Sanjay is the husband of
Oh, the father of accused number 2 assaulted PW on Joy. Oh, so it is here.
Yes.
Sanjay is there. So there are 4 injured persons there. He has been assaulted by father of accused number 2. Who is the father of accused number 2?
My father is
Khudiram.
Khudiram.
But Khudiram was not an accused.
My Khudiram passed away within 5 days of the incident.
Oh.
Which was relied upon in the conviction. I have not read that judgment, my lord, but what I understand from the deposition, my lord, that Khudiram perhaps died as a result of this couple, which was a reason why the why Sridham and they were convicted in the counter.
Both the cases have not been tried together.
No, my lord, I see different trial numbers.
No, trial numbers would be different.
Perhaps not trial together. That judgment was read on.
Ought to have been. No, it may so happen this since this is an outcome on 156 clause 3, it has been delayed. Be that as it may, whatever may be that. Be very good. PW1.
That is declared not guilty by completely charged.
Yes.
Thereafter, my lord, in a page number 6, PW1, my lord.
I'm telling you, I'm rather sharing you that to both of you, because
I shall, I stand corrected, my lord.
Madam.
Usually it is sent back again. The charge is framed properly. Again, the trial. You know, that is the. My lord, in most of the, even I've seen Mr. Basu, Mr. Shekhar Basu, always first thing that he looks into an appeal is the charge. If he finds the charge defective, the first point he comes and argue, he will argue on charge, and he will ask to send back the entire, to set aside the judgment and to de novo again the trial should be started on remand. These do both Both those parts, my lord, are actually very vital when one is appearing for the defense. Charge and 313. If 313 is also defective, I had appeared in one of the cases where 313 there were only 4 or 5 questions asked. Probably not entering into any of the PWs what they had said and all. My lord, from that part again it was sent back.
PW1 is the recording officer of the complaint.
Is this evidence very relevant according to you?
Just a part of it, my lord, if you were to consider that on the basis of the I received complaint under 150.
So please skip over. Skip over. Recording officer is not my vital.
Very. And PWs.
No, not my sake. If you say it is for your interest, you say.
It's not. It just stated that he has started the complaint.
Very good. I know that.
But thereafter, PW2, my lord, even on page 7.
Who is he?
My lord, he is the complaint of the incident case. My lord, Mihir Machiko.
So he is the informant.
Informant. He is also the son of Sridhar.
Very good.
Injured person, my lord, based on this establishment.
Yes.
Well, I start from the very top, my lord.
Yes.
I am resident of Peko on 17/5/97 at about 3:30 p.m. Incident took place when I was in my house. I, along with my brother, were wearing newly cemented plastered wall. Now, my lord, your lordship note this is when I, along with my brother, were wearing new. They were addressing the newly plastered wall. Thereafter, my lord, then Shoktavati Majiko, wife of Kiren Majiko, came and started abusing. I protested and she, who is such and such of Kalachan. When I raised voice, my father Sidam Maji appeared. Then Kiren assaulted my father with a rod on his right shoulder. As a result, My father fell on the ground. Ajit came with a kural axe and gave a stroke on the head of my father and sustained bleeding injury. Sanjay Majiko rushed toward the PO and Khudiram assaulted Sanjay with a lathi. Sanjay then pushed Khudiram down the earth. Now this portion is very relevant, my lord. And Khudiram assaulted Sanjay with a lathi. Sanjay then pushed Khudiram down to the earth. Khudiram died within 5 days of Khudiram is the father of Ajit.
Who are the appellants here?
One is Ajit Maji and Dhiren Maji.
So allegation is Dhiren is very good. Assault by rod and Ajit with Kural. Sanjay Maji go rushed towards the PO and Khudiram assaulted Sanjay with a lathi. Very good.
And Subhadra is the wife of Sanjay who was allegedly assaulted while being in an advanced pregnancy.
Sanjay then pushed Khudiram down to the earth.
Thereafter, my lord, Subhadra, wife of Sanjay, came to rescue.
Sanjay is who is Sanjay?
Sanjay is the husband of Subhadra and one of the sons of Sriram. Sorry, my lord, I stand corrected. Sanjay is the brother of Sriram.
Brother of
Sriram.
Sridham.
Sriram.
Victim. Victim's brother.
Victim's brother.
Then what happened?
Subhadra, wife of Sanjay, came to rescue her husband and Dhiren assaulted Subhadra with a lathi, causing injury on her person. Then she was expectant mother of 9 months. Sriham Maji, my father, taken to Adra IC in secure condition and narrated the incident to IC Adra. I was advised to take my father to hospital for treatment and then to report to the PS. My father was admitted in Raghunathpur SG hospital and he was hospitalized in the said hospital for 8 days. Thereafter, he was referred to Purulia hospital and there he was hospitalized for about 9 days. Adra IC did not start any case on our verbal complaint, so we came to Raghunathpur court and lodged a written complaint. I visited IC Adra for 4-5 times and ultimately learned that no case was started, so we lodged the complaint in court. The written complaint was drafted by the Gautam Day advocate at my instruction, which was read over and explained to me, and then I put my signature on the petition. This is marked as the accused persons are present and identified. Now, my lord, your lordship kindly notes this. He goes to Adra PS, he goes to Adra IC, lodges a complaint because purportedly he had complained verbally, which was not noted, sir. Thereafter, he had given a written complaint drafted by his advocate, based on which no case was started. Thereafter, my lord, he directly comes to the learned court and files a 156 clause 3 petition, my lord. He does not report to the superintendent of police as envisaged in 154(3)(1). Now, although that is not mandatory to go through the superintendent of police, pilot, but it can be said that that is the practice. If the officer in charge of that is the law laid down, my lord. If the officer in charge of the police station does not record a complaint, the informant of the aggrieved or the aggrieved person, my lord, is to go to the superintendent of the police, whereupon he can direct the officer in charge to register a complaint. Now, here, my lord, the complainant does not do that. The complainant directly goes to the learned court and files a petition under 156 clause 3. Thereafter, my lord, the cross-examination starts. I studied up to class 8, but this paragraph is not very relevant. My lord, I take your lordship to the third paragraph. Third paragraph starts, the present accused persons have filed a case. Your lordship has the paragraph. The present accused persons have filed a case against us, including my father. I cannot say if my father was arrested by police.
Father means Sridham.
Sridham, father means Sridham. I cannot say if my father was arrested by police. Labu Maji is my mother. My mother was arrested by police. Now, this portion is again very relevant. I cannot say if my father was arrested. Now, my lord, kindly recollect in the FIR, the 156 petition matter, it was averred that the delay, the explanation to the delay was the injured person was in police custody, was in jail. So that is why the injured person could not lodge a complaint on time. Now, my lord, in cross-examination, the complainant admits that he cannot recall if his father was arrested by the police. He admits that his mother was arrested by the police. Thereafter, my lord, police did not visit our house. Now, this is also very relevant. Why, my lord?
No, just a minute.
Yes.
In course of investigation, the PW 1, 3 and 4 had been arrested. Who are PW 1, 3 and 4?
My lord, one is complainant.
Hmm.
4 is the victim, my lord. 2 is
No, PW 1 means Labu Maji,
Babu Mati.
Chandra Maji, Subhadra Maji and Sridham Maji. Yes.
That is perhaps Babu Mati was arrested, which is PW 5.
No, no. Come to page number 4 of the paper book. Read the paragraph number 3.
That the accused person and safety valve also lost the counter information and after I enforced the investigation. The PW 1, 3 and 4 had been arrested.
Just a minute. Who are the PW 1, 3 and 4?
One.
Come to page number 2. Come at the last portion. PW means prosecution witness. Labu.
Who has recorded the who is the recording of that is perhaps typographical error. PW 1, my lord, is Police Kumar Taluk.
No, no. Come to page 2 of the paper book. There is the first page of the petition of complaint. Come to the last person, witnesses. PW 1 is Labu.
PW 1 is Labu.
PW 3 is Sanjay. And PW 4 is the Sridham. So you have rightly pointed out that I cannot say my father he was arrested by police, which is contrary to the version in paragraph number 3 of the complaint. It is your case.
This is the contradiction.
PW means prosecution witness. You are not aware of that?
Yeah, it is referring to the prosecution witness stated in the paper.
No, 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 no. PW here it has been PW means the
witness is
mentioned in the 156 clause. Just a minute. Come back tomorrow. Take down. এটা ঢুকিয়ে রাখো।
Tomorrow I might be in a little difficulty, my lord, because today is the Survey Barat Rat. So
Oh.
tomorrow I might not come, my lord. I'll try my level best because there are a lot of bail matters and all. So in
Ask your
case
junior to
yes,
remain.
somebody will be there, we'll take
Yes.
down, my lord. I'll address your lordship on Monday.
Very good. This court has heard Mr. Ghosh. First.
And this morning that what my lordship said is that he has not received the paper. Now
No, no, you have received the paper book. No. Yes.
Which day?
You please say. No, that cannot be done, ma'am. If you have got some difficulty, ask any.
I'm also there.
There's also some difficulty.
That's sir, ultimately, your judge is to hear the case and write the on the judgment.
Then my lord,
So I am
kindly-
to fix it according to my own business, no?
then my lord,
Let me remain in the list as soon as possible, it will be taken.
my lord, let it be not tomorrow, lordship, on this, because tomorrow.
Ask for any accommodation, I shall consider.
Because on the last occasion, I am appealing for SEBI, I have taken adjournment. That is why-
Usually, I do not pass adverse order in criminal matters.
Yes, sir.
But